Mr. Hill, we laid on your desk there an amended D5. We're back on the record on jury instructions. When we left on Friday, I gave the defense an opportunity to comment further on S3, dealing with the timing of the robbery versus the alleged killing versus alleged robbery, whether the intent to rob had to be formed prior to the alleged killing. I was the opinion that as long as it's a continuous transaction, it didn't matter, and advised the defense that's what the court's opinion of the law was, and gave you an opportunity to provide me with any law that rebutted that. I didn't receive any, so I'm working under the assumption that you doesn't have anything to rebut that theory, that statement of the law. I'll let you make any arguments that you want at this time anyway.
They haven't proven a robbery. They haven't proven a robbery.
I think that's a question for the jury. I just get into the law. The jury gets into the facts anyway. As to, there's testimony of what property was traditionally in the possession of the defendant, Mr. Carpenter, and what was no longer there anyway. And I think that that's a jury question whether there was a robbery or not anyway.
Yes, sir.
All right. All right. I'm going to give S3, which says the court instructs the jury that the state is not required to prove the defendant had the intent to rob Kirby Carpenter prior to the killing to support a conviction of capital murder with the underlying felony of robbery. It is sufficient for conviction if the state proves that the crimes murder and robbery were connected in a continuous chain of events. Intent to commit the robbery may be inferred by all the circumstances surrounding and connected with the killing of Kirby Carpenter. I'm going to give at S3. We also left here Friday with the question of whether the defense was entitled to an alibi instruction. I think at that time there was a D1, D2, and D5 that all dealt with alibi instruction. The court's opinion that is the defense theory of the case, and the defense is always entitled to an instruction on its theory of the case if there's any evidence, even more, regardless how scant, that supports the instruction. So I'm going to give an alibi instruction. We're down to which one of these instructions that I'm going to give. We had some emails yesterday, and the state was objecting to the first paragraph of D5, and I've taken the liberty of, and I agreed with that, and took the liberty of deleting the first paragraph of D5, so we're down to D1, D2, and an amended D5. The defense has indicated they want alibi instruction, and they are entitled to a alibi instruction. We're just arguing over which one it's going to be now. Mr. Hill, I'll give you an opportunity to express which of the three you think is the appropriate instruction. I'll give the defense state an opportunity to express which they feel is an appropriate instruction, and then I'll make a decision. If y'all would, tell the jury we out here working. We're not just drinking coffee and eating donuts, even though I have been eating donuts. Good morning, young lady.
Good morning.
I'm going to maintain my position for the record that D5, as we submitted it last week, is appropriate it's an accurate statement of the law, and that's the one that we prefer.
Let me, Lynn, did you have that original D5 that?
I have it right here.
She got me a copy coming here.
Sorry.
I think the first paragraph of D5 has been more than adequately covered in at least 2 prior instructions. So I don't think that the first paragraph is necessary, and I'm going to refuse D5, the original.
Is this the one that you're giving instead?
Do what?
Is this the one you're giving
That's the one
instead?
I'm proposing without the first paragraph. And so you have your position on D1, D2, or that amended D5 that you've got there without the first paragraph.
Well, I prefer my original that I submitted last week, but
I understand that.
I will accept the one that I have in my right hand.
Okay. You're going to get one.
Yes, sir.
Either D1 on alibi, D2 on alibi, or D5 on
I
alibi.
prefer your amended version.
On D5?
Yes, sir.
All right. State had any objection to giving D5 in lieu of D1 and D2?
No, sir.
All right, I'm going to give D5 then as amended. I thought that was the most succinct statement of the law. All right. So I'm going to go over the instructions that the court is proposing to give, and if you've got any objection, and I'm going to give them in the order that I'm fitting to call them out anyway. Court's going to give court's instruction 1, court's instruction 2, court's instruction 3, court's instruction 4, court's instruction 5, court's instruction 7, defendant D4, D5, S3, S2, and I'm going to conclude, last instruction will be S1, the elements and the form of the verdict. Other than any objections already raised, is there any objections to the court's instructions that I'm going to give?
Nothing to say.
Nothing more than what I've already.
All right. Is everybody ready to bring the jury in?
Yes, sir.
And I believe you said we're going to have an hour for, each side have an hour for closing statements. Do you want me to give you a warning on 30 minutes, or you just want to talk till you're tired?
I'd rather just keep going.
Do what?
I don't think I'm gonna take 30, but,
I'll give you a 2-minute warning on 30. How about that? Mr. Hill, would you like a warning on your hour?
Maybe 5 minutes, but I'm not going to take it.
Okay. Give me just 1 minute to gather some stuff. I'll be right back. Y'all be getting your jury ready to come on in, okay? when the jury gets out, I'll spend about 10 minutes reading the jury instructions. The state will then have,
I'm sorry,
go ahead. You need me to?
I interrupted her. You can keep going.
Okay. Be prepared to sit for about 40 minutes. We'll have a little, if you need a little break then, you want to leave at that time, you can, then be prepared to sit for about another 45 minutes to an hour. I don't want anybody coming and going when the attorneys are making their closing arguments. So, and then you'll have about another. So don't get up and leave during the closing arguments. And Mr. Bailiff, once they start their closing arguments, don't let everybody come in until they have a break, okay? I don't want to be any eruptions, all right?
Your Honor, I'm missing an exhibit.
I didn't get it.
Okay.
I promise.
36.
36. 36 is, it's been omitted. Safety box, easement and log, Saltville branch. You find it?
It's at the very bottom.
I knew it was going to be there.
All right, hold on.
Miss Kathy's in charge.
Miss Kathy, what?
You was in charge. I know you had your stuff together. Let's. I want to talk. Y'all come up here and approach Thad or Ben or somebody. Inventory anyway. I'm not rushing anybody, but are you ready? Which is sort of like rushing you.
We're ready.
I need to lay my hands on a couple of exhibits.
I'll get, let me do this. Let me give you an opportunity between the state's closing and your closing, okay? Jerry's been waiting long enough.
Yes, sir, thank you.
And I'll have these instructions available if you want to use them when you close it, okay? All right, show the jury in if they're ready. believe you got to stand, Mickey, so everybody can see you. If you would, okay. All right. Look like everybody survived the weekend. Good morning, all. Had some good football games. Some turned out the way I wanted, some turned out the way I didn't want anyway. I trust no one had any problems with the court's instructions not to investigate the case, not to discuss the case, not to form or express any opinions about the case. If you've had any problems in that regard, let me know. If not, if you don't let me know, I'm assuming you haven't. All right, at this time what I'm going to do is I'm going to read you the instructions of law, what the law is. As I told you, if we started this thing, I get to decide what the law is. Y'all decide what the facts are. After I read the law to you, the state will make its opening, closing arguments, and then the defense will make its closing argument. And because the state bears the burden of proof, they'll get the last bite at the apple and have the last closing argument. So pay attention as I read these rules to you. Members of the jury, you have heard the testimony, received the evidence introduced in the course of this trial. The court will presently instruct you as to the rules of law which you will use and apply to this evidence in reaching your verdict. When you took your place in the jury box, you made an oath that you would follow and apply these rules of law to the evidence in reaching your verdict in this case. It is therefore your duty as yours to follow the law which I shall now state to you. On the other hand, it is your exclusive province to determine the facts in this case and to consider and weigh the evidence for that purpose. The authority thus vested in you is not an arbitrary power, but must be exercised with sincere judgment, sound discretion, in accordance with the rules of law stated to you by the court. Both the state of Mississippi and the defendant have the right to expect that you will conscientiously consider and weigh the evidence and apply the law of the case, and that you will reach a just verdict regardless of what the consequences of such verdicts may be. It is your duty to determine the facts and determine them from the evidence produced in open court. You should not be influenced by bias, sympathy, or prejudice. Your verdict should be based on the evidence and not upon speculation, guesswork, or conjecture. You are the sole judges of the facts in this case. Your exclusive province is to determine what weight and what credibility will be assigned to testimony and supporting evidence of each witness. You are required and expected to use your good common sense and sound honest judgment in considering and weighing the testimony of each witness who has testified. Although you are the sole judges of facts, you are duty bound to apply the law as stated in these instructions to these facts that you find them from the evidence before you. You are not to single out one instruction alone as stating the law, but you must consider these instructions as a whole. Neither are you to be concerned with the wisdom of any rule of law. Regardless of an opinion you may have as what the law ought to be, it would be a violation of your sworn duty to base your verdict upon any other view of the law than that given. Arguments, statements, and remarks of counsel are intended to help you understand the evidence and apply the law, but are not evidence. Any arguments, statements, and remarks having no basis of evidence should be disregarded by you. The evidence which you are to consider consists of the testimony of the witnesses and the exhibits offered and received. Production of these evidence in court is governed by rules of law. From time to time during the trial, it has been my duty as judge to rule on the admissibility of evidence. You must not concern yourself with the reason for the court's rulings, since they are controlled and governed by rules of law. You should not infer from any ruling by the court on these motions or objections to the evidence that the court has an opinion on the merits favoring one side or another. You should not speculate as to possible answers to questions which the court did not require to be answered. Further, you should not draw any inferences from the contents of those questions. You are to disregard all evidence that is excluded by the court from consideration during the course of the trial. You are not bound by any rules of parliamentary procedure in your organization or in your deliberation. But the court suggests that you choose a person to speak for you. You may vote on your individual beliefs either by show of hands, secret ballots, or any other method you choose. If in stating the law to you I repeat any rule, direction, or idea, or if I state the same rule in a different way, no emphasis is intended, and you must not draw any emphasis therefrom. The form of your verdict is suggesting another written instruction or instruction. Your verdict may be in one of the suggested forms. It should be written in the handwriting or printing of one of the individual jurors on a separate sheet of paper furnished to you for that purpose. None of the individual jurors has to sign your verdict. The order in which these instructions are given to you and the manner in which these instructions and exhibits are numbered has absolutely no significance. You will have with you in the jury room all the papers and evidence applicable to this case. Although during the trial other papers, documents, exhibits, or charts may have been mentioned to you, once you have entered the jury room for deliberations, no other documents, papers, exhibits, or charts may be given to you. Transcripts of the trial testimony or parts of the trial testimony are not available. When you enter the jury room for deliberation, the court suggests to you that you discuss the facts of the case and review these written instructions before you begin voting or attempting to decide the case. The burden of proving the defendant guilty of every material element of the crime with the defendant is charged is upon the state of Mississippi. The law makes no distinction between direct and circumstantial evidence, but requires that before you can return a verdict of guilty, the state of Mississippi must prove beyond a reasonable doubt that the defendant is guilty from all the evidence in the case. The law presumes every person charged with the commission of a crime to be innocent. This presumption places upon the state of Mississippi the burden of proving the defendant guilty beyond a reasonable doubt. The presumption of innocence attends the defendant throughout the trial and prevails at its close unless overcome by evidence which satisfies the jury of his guilt beyond a reasonable doubt. The defendant is not required to prove his innocence or to offer any evidence at all. The verdict of the jury must represent the considered judgment of each juror. In order to return a verdict, it would be necessary that each juror agree thereto. In other words, all 12 of you must agree on a verdict in this case. It is your duty as jurors to consult with one another and to deliberate in view of reaching an agreement if you can do so without violence to your individual judgments. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your views and change your opinion, if convinced that your previous opinion was erroneous. But do not surrender your honest convictions as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Upon retiring to the jury room, you will select one from among your number to act as a foreperson. The foreperson will preside over your deliberations and will be your spokesperson before the court. If it becomes necessary during your deliberation to communicate with the court, you may send a note by the bailiff. During deliberation, no member of the jury should ever attempt to communicate with the court by any means other than a writing, and the court will never communicate with any member of the jury on any subject touching the merits of the case, otherwise in writing or orally here in open court. Bear in mind also that you are never to reveal to any person, not even me, how the jury stands numerically or otherwise until you have reached a verdict, unless asked by me in open court. Notes are only a memory aid, and the jury's notes may be used only as an aid to refresh that particular juror's memory and assist that jury in recalling the actual testimony. Each of you must rely on your own independent recollections of the proceeding. Whether you take notes or not, each of you must form and express your own opinion as to the facts of the case, and the individual jurors may be used by that juror only and may not be shown to or shared with other jurors. Jeffrey Dean Spence has entered a plea of not guilty. This means that you must presume or believe Jeffrey Dean Spence is innocent. This presumption of innocence stays with Jeffrey Dean Spence throughout each stage of trial unless the presumption has been overcome by evidence that satisfied the jury of Jeffrey Dean Spence's guilt beyond a reasonable doubt. Jeffrey Dean Spence is not required to prove his innocence. Jeffrey Dean Spence is not required to present evidence or prove anything. Because Jeffrey Dean Spence is claiming an alibi for his defense, that is, he was elsewhere on the date and time of Kirby Carpenter's death, the state has the burden of proving beyond a reasonable doubt that Jeffrey Dean Spence was not elsewhere at the time of Kirby Carpenter's death. The court instructs the jury that the state is not required to prove the defendant had the intent to rob Kirby Carpenter prior to the killing to support a conviction for capital murder with the underlying felony of robbery. It is sufficient for conviction if the state proves that the crimes murder and robbery were connected in a continuous chain of events. Intent to commit the robbery may be inferred by all the circumstances surrounding and connected with the killing of Kirby Carpenter. Robbery, as referenced in these instructions, means that the state proved the defendant unlawfully, willfully, and feloniously did take from Kirby Carpenter or from his presence his personal property with the intent to permanently deprive Kirby Carpenter of the property, and this was done against Kirby Carpenter's will by violence to his person or putting him in fear of immediate injury to his person by the exhibition of a deadly weapon. The defendant, Jeffrey Dean Spence, has been charged with a felony crime of capital murder. If you find beyond a reasonable doubt from the evidence in this case that Jeffrey Dean Spence, on or about the 30th day of November 2022, in Tippah County, Mississippi, y'all approach. It's been over the weekend, I forget. All right, I'm going to start the instruction over. The defendant, Jeffrey Dean Spence, has been charged with felony crime of capital murder if you find beyond a reasonable doubt from the evidence in this case that Jeffrey Dean Spence, on the 30th day of November 2022, in Tippah County, Mississippi, unlawfully, willfully, and feloniously killed and murdered Kirby Carpenter, a human being, with or without deliberate design to effect the death of Kirby Carpenter, while engaged in the commission of robbery, without authority of law and not in necessary self-defense, then you shall find the defendant guilty of capital murder, in which you should write your verdict on a separate piece of paper provided by the court for that purpose in the following form. We, the jury, find the defendant Jeffrey Dean Spence guilty of capital murder. If the state has failed to prove any one or more of these elements beyond a reasonable doubt, then you shall find the defendant not guilty of capital murder under the indictment, in which case you should write your verdict on a separate sheet of paper provided by the court for that purpose in the following form. We, the jury, find the defendant Jeffrey Dean Spence not guilty of capital murder. All right? Those are the instructions of law that are to govern the case. These will go back with you, and these written instructions will go back with you into the jury room. Y'all can consult those when you begin your deliberation. Is the state ready to make its opening and closing arguments?
Yes, Your Honor.
All right?
Thank you.
Y'all guard the door now. Don't let anybody come and go during this portion of it.
Thank you, sir. Yeah, that's fine.
There's a seat right over there.
May I proceed? Sure. Thank you. Good morning. The judge has instructed you on the law. As I said in my opening statement, you're the trier of fact. You judge the credibility of all the witnesses that you heard last week. And now, when you go back and retire and go back in the jury room and deliberate, you'll apply the evidence to the law and make your decision. And as the judge has said, you can take the instructions, should take the instructions back into the jury room with you. Now, Mr. Spence is charged with capital murder. We have to prove all the elements of capital murder beyond a reasonable doubt. The first element is that on or about November 30th of 2022 in Tippah County, Mississippi, while Jeff Spence was engaged in the commission of robbery, Jeff Spence unlawfully, with or without deliberate design, killed Kirby Carpenter, a human being. Those are the elements. November 30th of 2022. Kirby's last words to Caitlin were at 6:37 p.m. on November 30th of 2022. He was traveling past Gino's, which is a tire store in Boonville. Kirby is never heard from again. You can review the text messages. They're entered as an exhibit, and you will see that there are no outgoing texts or calls from Kirby's phone. Scott Watson, who was the deputy coroner that day, and Dr. Arian Robinson, who didn't testify, but her report and the death certificate were admitted into evidence, declared that the date of death was November 30th of 2022. We can see this from the death certificate, which is right here, admitted into evidence. And highlighted there is 11/30/2022 in the right-hand corner is the date of death. Tippah County, Mississippi. His body, no question, was found at 6071 County Road 600 in Tippah County. That's Kirby Carpenter's home. Now, let's talk about robbery. Robbery is just what you would think it would be. It's taking someone else's property by violence using a gun, in this case. A person is in the commission of robbery even if the robbery occurs after the killing. And the judge read you an instruction that tells you that as long as the state has proved that this is a continuing chain of events, the murder and the robbery, we don't have to prove which one occurred first. So even if Jeff robbed Kirby after killing him, he is still in the commission of a robbery. Now, let's talk about the property. You heard testimony early on in the trial from Bart Adams. Bart Adams is an attorney in Ripley, Mississippi. He knew Kirby for about 12 to 15 years, knew him, did some legal work for him, and he knew him as an acquaintance. He did business with him. He traded gold, silver, and collectible coins with Kirby. He also testified that in his dealings with him, Kirby always carried a satchel. I think Bart called it a man purse. And in that, I'm going to call it a satchel. In that satchel was cash and business documents. Now, he also always carried a pistol with him. The gun and the satchel were never recovered. They weren't on Kirby's person, they weren't in Kirby's house, and they weren't in Kirby's truck that was locked in the driveway with the groceries he had purchased at the Kroger in Corinth on 11/30/2022. 22 Magnum shells were found on Kirby's person at the crime scene when the body was discovered on December 2nd of 22, but no gun. So where'd the gun go? Something he always carried. Now, let's talk about the personal property, including the business documents. Where were they found? You got to look to the Chilhowie, Virginia branch of the Bank of America. These pictures have been entered into evidence, and the actual evidence you can take back into the jury room and examine. Now you'll see some, what Mr. Hill calls the commercially packaged items that you can buy on Royal Street in New Orleans, but you also see a lot of loose coins. These are all items that were part of Kirby's business. North Mississippi Gold, Silver, and Coin Exchange. Also contained in the Chilhowie branch were miscellaneous papers. I'll have more to say about that in a little bit. Jeff killed Kirby with or without deliberate design. Deliberate design. Now, what is deliberate design? Deliberate design means we don't have to prove that Jeff Spence intended on killing him. He killed him, but we don't have to prove intent. Jeff Spence shot Kirby in the right shoulder and the chest with a shotgun. Kirby's death was caused by a shotgun blast. Where do we get that information? From the death certificate. And the pictures that you saw that were presented in trial that showed the wounds to Kirby Carpenter's neck and chest area, right shoulder. The doctor, the medical examiner, ruled this a homicide, and the cause of death, which is in the right paragraph, gunshot wound, gunshot to right shoulder and chest area. Now, there's a lot of evidence in this case. We're going to take it one at a time because once you put all the pieces together, everything points to Jeff Spence. The timeline. In my opening argument, I suggested to you that the timeline is critical in this case. Kirby's timeline, Caitlin's timeline, and Jeff Spence's timeline. Again, Kirby's last words to Caitlin, to anyone, was at 6:37 p.m. in the form of a text message when he's passing Geno's. Again, here's the text message. You can see it 6:37 p.m. on November 30th of 2022. Where are you? Geno's. Now, if you recall, Caitlin's testimony was that on the night of, actually on the 29th, Jeff Spence suggested to her that she go out with Bailey Reeves, her friend, on the night of 11/30/2022. That didn't work out because Bailey had her baby, her husband was home, whatever. They did not get together. But Jeff suggested they get together. You gotta ask yourself why. Because he did what he had to do. We know where Caitlin was. We know Caitlin was at Walmart in Boonville. And we know she went to the parking lot. And how do we know that? Because we've got video evidence that's been entered into the evidence showing her at the Walmart parking lot, and she stays there until 7:52 p.m. Her testimony was that after she left, after breastfeeding, she went to pick up Chinese food and then headed home. 15 to 20 minutes to Kirby's house, where she lived. So that puts her, even if she's speedy picking up her Chinese food, that puts her home about 8:15 p.m. Kirby was murdered approximately 7 p.m. Now, Jeff and Karen left Mississippi after being in Mississippi for an extended period of time to, quote, help with the baby on 11/29/22, one day before the murder. 19 hours. I want you to remember that number. You heard the officers from Virginia testify that it was about an 8-hour drive. Caitlin said it was 10. Say it was 10. You've got an hour time difference. So when you're traveling to Virginia, you pick up an hour. When you're coming back to Mississippi, you lose an hour. 19 hours. So if the Spencers left Mississippi 1 to 2 p.m., giving them a 10-hour drive, adding an hour for the time change, that puts them home in Saltville, Virginia about midnight on 11/29/22. Kirby's killed at 7 o'clock p.m. on the 30th. That's a 19-hour gap. Plenty of time to get something to eat, to take a shower, to fill up with gas, get a good night's sleep, and drive all the way back to Mississippi. And again, Kirby was found at 12:30 on December 2nd of 2022. When did the Spencers say they come back? They came back on the 3rd, and they stayed for the funeral on the 17th, and then they left on the 20th. 19 hours. The bank box. The first bank box that was opened by Jeff Spence was opened on December 2nd of 2022. Guess what? The same day Kirby's body was found. There's the safe deposit box lease opened by Jeff Spence, co-owner Karen Spence. But what's significant is the box entry log. When does he enter that box? On the same day he opens it. At what time? 11:40. That's Eastern Standard Time, which is 10:40 Mississippi time. That's almost 2 hours before Kirby's body was discovered. If they didn't know he was dead, why they're opening up a bank box? And Mr. Hill made a big deal that, hey, you open up a bank box, nothing unusual about going into that bank box. But if you look at the Saltville branch documents, that box was opened up on December 12th of 2022, and the contents are in evidence. He doesn't enter that box until June of 2023. Why does he go into that box? On the day that he opened it, 2 hours before Kirby's body is discovered. Well, on December 4th of 2023, pursuant search warrants obtained by Virginia law enforcement, what do they find in the Chilhowie branch box? Number 11. This. And more importantly, more incriminating, not commercially valuable, is a check to David Barnes. Kirby M. Carpenter, 6071 County Road, 600 Boonville, Mississippi, $90. How'd that get there? Miscellaneous paperwork that Chris McAllister testified to. First is a simple envelope that you get from a bank when you withdraw money. Where's that from? People's Bank, Ripley, Mississippi. Bands are used to band money together. People's Bank, People's Bank. You gotta ask yourself, where's the money? It's in his pocket. And the receipts. Here's a receipt from Panther's Den in Dumas, Mississippi. Kirby's MasterCard. And here are some receipts that Chris McAllister testified that he verified that were from Kirby Carpenter's account. Now, what do these documents do in that box? Because Jeff Spence grabbed Kirby's satchel and left. Testimony is that his satchel contains business papers, documents, and cash. All that's found in the Chilhowie box. The confession. Caitlin Spence testified that in December of 2022, he had gone back to Mississippi on the 30th and delivered a package that he implied were narcotics, pills. Placed him in the shed, I believe, underneath a bucket. So here he's confessing to going back to Mississippi on the 30th. And then we have the waterfall conversation that Caitlin testified happened between April and June of 2023. After she's reading all these social media posts, she's gone through counseling, and she just comes out flat out and asks Jeff Spence, did you kill Kirby? What did he say? No, I didn't kill him. What are you talking about? The less you know, the better. Don't look a gift horse in the mouth. Down south, we would say that as don't thump a free melon. If you say anything, you'll lose, and no, you kill me. I did what I had to do. And Caitlin Spence testified that this was a confession. Now, Mr. Hill has made a lot of the purported enemies that Kirby had throughout his life. Drug dealers in Memphis, business transactions gone wrong. Out of all the people, Caitlin could have said, "Hey, look, he was dealing drugs with Joe Blow in Memphis. He killed him." Who did she point her finger at? The guy that confessed to her father, his own daughter. The shotgun. Carolyn Aguayo, Caitlin's sister, Jeff Spence's other daughter, younger daughter. First grade teacher, wife, mother. Has no reason, nothing to gain from her testimony. She doesn't want to be anywhere around Jeff. She doesn't want him to know where they live. She doesn't want him to know how many children she had. And he made the statement to her while watching TV that if he had to kill someone, he'd use a shotgun. Jeff knew it was easier to get away with using a shotgun because if you only fire one shot, the casing's not going to eject. Chris McAllister testified that it was a single shot from a shotgun. Now, significantly, again pursuant to a search warrant in December of 2023, Smith County law enforcement found a hidden, muddy, fully loaded shotgun under Jeff's bed. Pictures are in evidence. The shotgun was wrapped in a man's jacket. Muddy at the end of the barrel. Also important is the ammunition that was contained in the shotgun. He racked it 6 times, 6 shells ejected. I submit to you, the testimony was that the red shells are double aught buckshot. Chris McAllister gave me his opinion as a coroner that Kirby was shot with buckshot. Jeff's phone. Caitlin testified that she tried to call Jeff on November 30th of 2022. And she couldn't get it. And she asked him about this. And he said, "Oh, my battery was broken." All day? What was recovered in A1 storage was labeled a Faraday bag. You heard testimony what a Faraday bag is used for. Put your phone in there, nothing's coming in, nothing's going out. Easy way to hide your phone. Carolyn's testimony. What did she say about phones? She said that when Jeff had to cross state lines, he would give his phone to his wife so he couldn't be detected. You see a pattern here? Jeff's MO, modus operandi, how he gets things done. The shotgun. Kill with a shotgun, hidden underneath his bed. Why do you hide the shotgun underneath your bed? Wrapped in a jacket. Because you're trying to hide the murder weapon. Again, what the comment he made to Carol, if I was going to kill somebody, I'd kill him with a shotgun. The phone. Carolyn testified, yes, the phone to Karen so they couldn't detect him going across state lines. His phone has gone dark the day of 11/30/22. The security cameras. Now, you heard Carolyn testify that things had gone south with her parents. They had basically evicted him off their property. He came back to get his stuff out of the garage, and they watched him on the camera walk behind the shed, and then the cameras go blind. They go back to check it out, camera's been cut, recorded. Why did he do that? Chris McAllister testified that Kirby Carpenter's security system, the cameras, had been disabled. Now, Mr. Hill said, oh, he didn't have access to the house. Yes, he did. Caitlin testified that she had told her parents where the spare key was located. So he didn't have to break into the house. There was no sign of forced entry because he didn't have to. He knew where the key was. He lived there for several months. The aggression. I wrote this down, but during Carolyn's testimony, when they met at McDonald's to see if they could straighten things out, these are Carolyn's exact words. I saw an anger and a violence in his eyes that I had never seen before. I saw an anger and a violence in his eyes that I had never seen before. That's Carolyn's testimony. Someone has nothing to gain about being there. Caitlin testified at the waterfall, her father had never talked to her like that. He was angry. JDC, Jeff doesn't care. A text from November 5th of 2021, about a year before Kirby's murder. Jeff says, you hire the talent. The older I get, the less life in prison is a deterrent. Jeff doesn't care. The older I get, the less life in prison is a deterrent. That's a text in response to Caitlin's question, tired of a job, hey, what other work can I do? And he says, Assassin's Inc. That full text chain is entered into evidence. Kirby's house. Again, Jeff knew about the spare key, knew where it was. Jeff disabled the cameras. Because if he doesn't disable the cameras, all this is for naught. Jeff shot Kirby, dragged and tried to hide his body. Picture of Kirby's house in County Road 600 in Tippah County. Picture of the carport area. Looks like there'd been some kind of scuffle. And I say that because behind that white garbage can were found Kirby's house keys. Mud on Kirby's pants from being drugged. And that's where he ended up. Underneath the curtain, secured by a toolbox from a pickup truck. Now, Jeff's alibi. The court has instructed you that's the state's burden, and we accept that burden, to prove that Jeff Spence was in Mississippi. And I just went through the litany of evidence that shows that he was in Mississippi. But so we've got that burden, but let's look at the alibi. The alibi is based on one text, supposedly from Karen Spence to Caitlin. One text. About to cook hamburgers. Dad worked really hard today. The hounds are on the porch. That message. That brings the obvious question. Where was Carrie? This is an unverified, unsworn, self-serving text message. Anybody can grab a phone, go into another room saying, hey, I'm having fun in Alaska. Why didn't Karen Spence come into this courtroom, be sworn in by the court reporter, sit down and testify under oath? I sent that text message. I was in Virginia when it was sent, and my husband, Jeff Spence, was with me. Where was she? I don't know where she was, but she wasn't here. Now, if you're accused of capital murder, and you're claiming you were somewhere else, and you see the number of just miscellaneous documents that are in all these bank boxes. It's almost like you hoarded receipts and things. Where are the receipts? Where is the receipt from the gas station where you filled up with gas in Saltville, Virginia on November 30th of 2022? Where's the receipt saying you bought a Coke and some naps?
Pardon me.
Why aren't there any receipts? Because he wasn't in Saltville. Why isn't there someone to come in here and testify and say, yeah, Jeff and I were together on 11/30/22 in Saltville. We sat on the porch, had a Coke, because he wasn't in Saltville. This alibi, this unsworn, unverified, self-serving text message is not an alibi. What they're claiming to be an alibi.
You've used 28 minutes.
Thank you, but it's unsubstantiated. Why wasn't Karen here? Maybe she was tired of staying strong for the family, to continue covering up for Jeff. I don't know. All we know is she wasn't here. And you've got to ask yourself a question: how does a man with the financial troubles, with no continuing or employment whatsoever, how does he accumulate all this cash? If you look at the inventory sheets on the two bank boxes, he's got $62,000. That's just in the counted cash. That doesn't count the money that was wrapped in aluminum foil when he was arrested on November 30th of 2023, 1 year to the day Kirby died. I believe that was about $10,000. He claims that he deals in gold, silver, and valuable coins. Is there any dealer that came in here and said, yeah, I'll trade with you? And finally, the three people, his immediate family, who should be the most important people to him, his two daughters, both testified against him, and his wife didn't testify. That's got to say something. Confessed to Caitlin, Carolyn, again, a first grade teacher, wife, mother, credible, no reason to come in here and lie. They broke ties with, I think she called them Bonnie and Clyde. Scared of her. Don't want him to know where she lives, where her family is, how many kids she has. Jeff Spence had the motive. That's greed. Jeff Spence had the opportunity in 19 hours. Jeff Spence took this man away from Maddie Jane, his mother, his sisters, Casey and Wendy, and most importantly, his 2 children, Towns and an elder. Jeff doesn't care. Prison's not a deterrent to him. A deterrent to what? A deterrent to murder. He's guilty. Find him guilty. Thank you.
You let me know if you want a break. You could have to, Mr. Hill has up to an hour to have his closing arguments. I don't know if we'll use all of it or not, but if you'd like to have a break now before we start that, we'll give you one. You think you need one? Nobody says yes, I'm gonna say no. All right? You may make your closing argument for the state. For the defense.
If I don't speak loudly enough, let me know. Raise your hand. Just give me a sign. Let's review the timeline again because they're leaving a lot out. The Spence baby was born, the Carpenter baby, Enola, was born on July the 23rd, 2022. From that day forward, Jeff Spence and Karen Spence, either both of them or one of them, was in Tippah County, Mississippi, helping Caitlin learn how to be a new mother, taking care of the baby. I think Karen Spence was here almost the entire time, the entire 4 months. And Jeff would be here and go back, take care of their place in Virginia, come back, go back, and did that for that entire 4-month period. On November the 29th, that's a Tuesday, they both returned to Virginia. And that's a 10-hour drive, unless you are going a lot faster than you should. That's 10 hours. They left about 3 p.m. That's in evidence. 3 p.m. on Tuesday the 29th. Arrived in Virginia in the wee hours of the morning. I'll come back to the timeline shortly. Jeff opened a bank box on the 2nd of December, I'm sorry. He opened another bank box on the 12th. The bank boxes that he opened on the 2nd and the 12th were visited repeatedly in 2023. The pictures that you see up here are items that were in these bank boxes a year later. They talk about the Chill Howard bank box. What you see, the pictures wasn't on December the 2nd. It was in December of 2023, after search warrants were obtained a year later. Okay? The government claims, I told you when we started, the government claims things that they can't prove. They can't prove that Jeff Spence was in Mississippi on November the 30th, 2022. They can't prove that he was at Carpenter home. They can't prove that he did anything. There's no proof. No hard proof. There's nothing. No scientific evidence. Nobody saw him. He came all this way, did all this stuff, and nobody saw him. Now, on November the 30th, which is Wednesday, he was, in fact, with his wife at their home. And bear in mind now, they haven't been together in this home at that point for 4 months. She's been here in Mississippi. He's been coming and going. This is their first night, their first dinner as a couple in their own home in 4 months. Now, how do we know he's there? Well, 2 reasons. Number one, Karen and Caitlin have a text exchange. We all know what that is. We've got a cell phone. You write back and forth. I do it with my daughters at night. You know, just casual checking in sorts of emails. And this is qualitative evidence. You don't have to have it notarized. You know how I came into possession of this? Just so you know how this whole system works. This is not something I found and I did find it, but it's not something I produced. This is the product of what's called discovery in a lawsuit, in a court case. Discovery, that means giving information. And you know where this information was obtained? By them. This came from them. This text message between Caitlin and Karen came from the government. You know, when you get arrested, trust me, law enforcement types want your cell phone. They love your cell phone. They love to go through it and see what they can find. And that's what they did in this case. This is what they do in every case. They get your cell phone, they get a warrant to go into it, they go into it, and you've heard the word dump it, they dump it, extract it, dump it. And this produces information. It produces information. And the information that they produced, and they didn't know how to find it, because when I get the phone dump, it's thousands. It's not just, oh, look here, I have to go digging for this. I guess they thought I wouldn't find it. Caitlin and her mother, y'all have this with you when you're back there. Caitlin and her mother are having this casual evening checking in sort of exchange of, what's for dinner? Really enjoy seeing Noah. She's such a doll, that sort of thing. And then Karen says, Dad and I are eating hamburgers in a few minutes. He just got up from a good nap. He worked hard today, inside and out. The hounds are back. I don't know what that's a reference to. Love you lots and lots. And then Caitlin writes back, LOL, good. I'm glad to hear that. I know you missed his hamburgers. Thank you so much, both of you, for helping out so much with the NOLA. You are the best grandparents. I don't have to have that notarized. This is qualitative evidence. that they discovered in a cell phone search, and it tells you that Karen and Jeff on November the 30th are about to have dinner for the first time together in 4 months. First time together in their own home in 4 months. Help you understand how to read these things. If you look at some of the small print on this text message right here, you will see that it was sent on November the 30th, 2022 at about 8 p.m. I hope you were paying attention when I had Caitlin on the witness stand the other day. She didn't know I had found this. I don't have to tell her what I found. They have to give me the phone number, but I don't have to tell her what I found. I could bring it up in court, which is what I did. And when she was sitting right there, and I started quizzing her about this, if you were paying attention, I hope you were. She was stunned. She didn't know what to say. And when I asked her, kind of difficult to kill Kirby Carpenter in Mississippi on November 30th, 7 or 8 p.m. and be in Saltville, Virginia, having a hamburger dinner at the same time. Isn't it, Kate? Isn't it? Difficult. Remember, all she could say was, this is a quote. That's what it said. I could only retort to my question, how do you explain killing somebody in Mississippi and being in Saltville having dinner with your husband? Well, that's what it says. And that's what it says. She didn't need this waterfall confession. Waterfall confession never happened. This is, Caitlin Spence is up to her eyeballs in all this. I'm not sure you'll ever get her whole truth. And she knew she was up to her eyeballs in all this. She was the first one investigated. She was the first one to lawyer up. And what she did in April of this year is get herself some relief. And you don't get relief from the government just because she wants some relief from the government. You gotta give them something. And so she makes up this story about a waterfall confession, wanted to hear it from her father. And she knew on November the 30th, 2022, exactly where her father was, exactly where he was on November the 30th, 2022. Because on that day, she was communicating with her mother about hamburger dinner they're fixing to have, and then Caitlin says, I know you've missed his hamburgers. She knew where her father was on November 30th, 2022. She didn't have to go ask him. It never happened. She's making it up. You know, what got Jeff Spence arrested initially was a statement from this guy named David Barnes. David Barnes was in trouble just like Caitlin was in trouble. David Barnes was facing life imprisonment because he's a career criminal. And he went and gave a statement in 2023, a year after the time frame that we're talking about with Kirby. He went and gave a statement to Chris McAllister about something he heard at the funeral. Well, Caitlin, you heard her say, I asked her about that. Something that Caitlin said to him at Kirby's funeral. And Caitlin says, that's a lie, and never happened. David Barnes is making it up. He's making up something that he can sell to the government to get him some relief. And it's got him some relief. He's not shipped off to prison yet. Interesting facts. That's what got Jeff Spence arrested. David Barnes' statement in November 23. Well, what David Barnes did in November 23, trying to get himself some relief from law enforcement, is exactly the same thing that Caitlin Spence did at the waterfall. She's making it, nothing happened at the waterfall. She's making it up. She's making it up to be as plausible as possible. She didn't have to go ask where her father was on that day, on that night, November 30th. She knew it was right there. She and her mother were talking. I hope you take note that David Barnes, who started this criminal case against Jeff Spence, was not brought into the court. They didn't bring him. And there's a reason. Because he's not credible. And another reason they didn't bring him is because they had two competing witnesses. One saying one thing, no, you're a liar. Okay? When we first met each other last week, I told you to make sure that you make the government prove its case beyond a reasonable doubt. Make sure you make them prove that Jeff Spence was in Mississippi on November the 30th at 7 p.m. beyond a reasonable doubt. Following the timeline further, they want you to believe, I told you, that they concocted this theory that Jeff went Mississippi to Virginia, came back to Mississippi, did the deed, went back to Virginia, with no proof. There's no proof of any of that. None. Zero. Is that beyond a reasonable doubt? And to follow up their preposterous, foolish, almost theory, they create this almost impossible allegation that we left Mississippi in the afternoon of the 29th, drove all the way to Virginia, turned around the next day and drove all the way back to Mississippi, and then turned around and went all the way back to Virginia. Now look, they're saying that he drove 30 hours over the course of 36 hours. He left Mississippi at 3 p.m. on the 29th. Drove 10 hours. He got to Virginia in the wee hours of the morning. He turned around and drove back to Mississippi. That's another 10 hours. It would be from 3 p.m. on the 29th to 3 p.m. on the 30th would be 24 hours. Right? That's a day. 24 hours. Kirby is supposedly killed at 7. That's 4 more hours. And then we turned around and drove back. And that's another 10 hours or so. They're saying he drove 30 hours in 36 hours. 30 hours and 36 hours. That's over 2,000 hours. And what makes their theory of his conduct even less believable is that You know, the evidence is that Kirby was a very independent-minded sort. Lived life on his terms. If you don't like what I'm doing, to heck with it. You'll see me when you see me. I'm not coming home, I'm not coming home. And there is no expectation. Jeff is going from Mississippi, Virginia, back to Mississippi, and he is just coming back to Mississippi on the hunch that he might encounter this man. I'll just drive to Mississippi and see if I can run into him. Well, who in the world is going to do that? It makes no sense. It's foolish. So, the notion that we did that is not plausible. It's not credible. The notion that we would even attempt a man that age, I mean, he's no spring chicken. And I see some younger folks in this jury box, y'all might be able to pull that off. But not many of us my age could. He's not far behind me. No. We have several items to talk about. Please bear in mind that a search warrant was had on the Jill Howie bank box on December the 2nd, 2022. Mr. Mueller has shown you all sorts of photographs. Those photographs aren't from December the 2nd, 2022. Those photographs are from a whole year later. They don't have any proof as to what was open in that box on December 2nd. You can just open the box. There hasn't been anything to it. It doesn't, certainly not what you saw on the screen. And then the next box was opened on December 12th, 22. And it didn't have anything in it until June of 23. Jill Howie box was visited 4 times in 23. Other stuff going in before the photographs were taken. The Saltville, I mean, yeah. The box opened on December the 12th. Didn't have anything in it until June of 23. And certainly nothing was put in it that looked anything like the photograph that you saw on the screen. These photographs, trust me, are not contemporaneous with this time. They are different. They are not contemporaneous at all. When we bring a witness in named Carolyn, who hasn't even seen these people in 7 to 8 years, hasn't even seen them, and they're going to use her testimony as some sort of convincing evidence. She hadn't been around Jeff Spence, Karen Spence, our sister Caitlin Spence. She hadn't been around the entire family for a year. And she's so full of hate and vengeance, I'm pretty sure they don't care. You know, she lost me when she told y'all that her mother's illnesses were a matter of convenience. That when her mother needs an excuse, she's got health problems. A matter of convenience. That's the least respect you can show your mother. I think you don't want to talk to me. And Damn sure not gonna do it. They haven't proven anything in this case. They haven't proved our presence, they haven't proved our, any conduct at Kirby's house. They haven't proved that we knew how to get into the house. They haven't proven that we committed a robbery. What did we rob? They haven't proven any robbery. They haven't proven anything. They haven't proven that there was any attempt to go into Kirby's safes in the house. No damage, no attempt, nothing broken, no locks picked. From the November the 30th supposed murder. No doubt that was a murder, but it wasn't Jeff Spence. I haven't figured out yet, I've been sitting here for a week, I haven't figured out yet what exactly they claim was taken on November the 30th, the day that Kirby was murdered. What do they claim was taken? Do they honestly want you to believe that all of this stuff, right here, all of this stuff, that Kirby's killer killed him at 7 o'clock, and loaded all this up before Caitlin got home at 8:15? That's what they say. I don't agree with that. That's what they say, using their timeline. All of this stuff? No. This is evidence of accumulated activity over the course of a long time. You remember I had Mr. Johnson, a young investigator from Virginia, on the stand for a couple of hours, going through every item in that box, and that box, and that box, and that box. Every item. And every item in there, they showed some loose coins. There weren't any loose coins that I saw the other day. I asked him about loose coins, and he said, they're not loose coins. They are commercial products. You'll get to see it. You can look at it yourself. An individual silver piece, or silver dollar, or whatever. And it's packaged in a hard plastic container that could be bought, I always say Royal Street, because I had bought stuff there myself when I knew Portland was. But you can buy it in Memphis. You can buy it in Birmingham. Anywhere where there are products of this nature sold. And Mr. Johnson was asked, have you seen any evidence, Mr. Johnson, of when Jeff Spence came into possession of these items? No. Nothing. No. Couldn't say. Could have had them for 40 years. Could have had them for a year, 2 years. Who knows? They don't have any proof. I told you the other day, they're just trying to squeeze whatever evidence they can and make it as punitive as possible against Jeff Spence. Trying to put, I use the analogy of trying to put a square peg into a round hole. They've been doing that for over 2 years. Right? And they always want to catch it. They want to catch everything they do. It's a government tendency to make it as bad sounding, sinister sounding as possible for the accused. And the example that I'll use for you, if you look at they make out a return when they do evidence. They have a list. There's a list. You'll see the list. And they accuse Jeff Spence of possessing, on the day that he was arrested, $8,200 in counterfeit money. Well, that sounds pretty bad. $8,200 in counterfeit money. He didn't have one red cent in counterfeit money. He saw me have Mr. Johnson, let's look in this bag. Let's open it up and see what's in here. Remember that? And we opened the bag with $8,200 in supposed counterfeit money. Well, it wasn't counterfeit money. It's play money. It says it, you look at it, it says it right on the document itself. You flip it over on the back side, it says, profit. Profit, it's a profit, money, movements and stuff. Profit pack. It's a profit pack. That's simple about that big. It's not counterfeit money. Oh, so we wouldn't even try to pass it. What's left, we'll take it. It's not right. If Kirby supposedly, if Jeff supposedly brought pills that Caitlin said was brought, why were they never found? It didn't happen. Caitlin's just making stuff up to protect herself. Caitlin's making stuff up to shift the blame. Caitlin's making stuff up to earn her freedom. She's free. She's happy. She is a free person with her daughter. They say I blame her. I might have done it myself, but that doesn't mean she gets to pass it off to somebody else, which is what she's trying to do. I think you need to bear in mind how much animosity Kirby had going on at the time, and how much animosity he has generated over the course of his young life. How many people wanted to do him harm? How many people threatened to shoot him in the face? Not just shoot him in the face. How many people wanted to drag him out to the street and beat him to death in the city of Ripon, where nothing would happen to him, is what he said. I mean, the people got mad at him over manipulated business deals. I mean, the people got mad and said that's the kind of money to get killed over. All sorts of questions. Somebody killed Kirby Carpenter. Who was it? Have they proven to you beyond a reasonable doubt that it was Jeff Spence? No, they don't have any proof at all. Besides, I just showed you. On November the 30th, at the time he supposedly was in Mississippi to do this deed. He was at home in Virginia with his wife, and she is telling the daughter that, and daughter knew it when she went to talk to her, or claimed she went to talk to her husband or her father. And what year was it? 23 or 23? April of 23, June of 23. No. Just didn't happen. The government wants to direct your attention to some other specific facts, like a shotgun found in a house in Virginia. What's so big about that? There's no connection There's no evidence at all connecting that gun to Mississippi. None, zero. It's just another example of trying to make the evidence. Let's see if we can make it. And how many people own a shotgun? I own 5 of them. So nothing wrong with owning a shotgun. Nothing wrong with putting it wherever you're going to put it, back on whatever you're going to do.
Can we approach her?
I told you that you should pay particular attention to Caitlin Spence and her effort to get out of trouble and whatever she said about her father, and analyze these facts carefully as to her. Kirby was a drug dealer, and she was right there with him. Okay. Kirby sold methamphetamine, she was right there with him. Kirby sold pills, she was right there. Drug dealer, trust me. 50-year lawyer. There's a lot of violence associated with drug dealing. And she was right there with him. You know, going to Virginia, driving back, going back to Virginia. That's a lot to believe when you got this woman right there in the house with you. You got this woman right there in the house with you. And not only do you have her right there in the house with him, but they had a history that wasn't always flowers. It wasn't always positive. She told you, and other people told you, Kirby was a difficult man. He had temper. He had a tendency to violence. If you didn't agree with the way he wanted to live, Kirby was emotionally abusive to her. When I say emotionally abusive, I'll come on if I want to. If I don't want to, I'm not going to. And if you say anything, I'm liable to give you a black eye. And he did. I don't believe Caitlin was happy in that relationship, and I think she's glad it's over. And one of the things that I found interesting that I didn't even know until this case was being heard. Chris McAllister was on the witness stand, and he wanted to play the 911 tape. And you heard after the dispatch answers the phone, answers the 911 call, then we have a very emotional, crying, upset young woman. And Chris suggested to you that that was an act. And I suggest to you that it was an act for her to cover her own interest here. Remember what Chris said? A 911 call is recorded. It's recorded before it's answered. And when that 911 call was made, Caitlin wasn't crying before the phone was answered. She wasn't upset before the phone was answered. She was upset when she acted upset when the dispatch said, hello, or what's your emergency? That's when the crime started, in that space of time between making the call and it being answered. There was nothing. Caitlin was manipulating the situation. Caitlin was trying to deflect attention away from herself, just like she's done with this supposed waterfall story. It doesn't hold water in view of her discussions with her mother on the night of November 30th, 2022. Dad and I are fixing to have a hamburger supper at the same time that Kirby's supposedly being killed. Just doesn't wash. Doesn't hold water. You know, Chris McAllister is a long-time Temple County coroner and a long-time Temple County investigator. I've known him a long time. He usually shoots straight with me. And I think he shot straight in some arrows, but basically in this case. I don't recall anything from his investigation, what he did, that in any way connects Jeff Spence to here, to this case, to this murder on November the 30th, 2022. Chris did all this investigation, and I can't think of a single fact that he could testify to that points the finger at us. There's no connection between cameras. There's no connection. There's no proof of any connection between surveillance cameras. There's no proof of any connection concerning any sync module. There's no proof of any connection between any attempts to steal money from inside safes. There's no proof of any connection between any supposed hard evidence, scientific evidence, forensic evidence. All we've got here is theory and everything they can do to make whatever they find fit that theory. Of course, Chris did make some mistakes. I mean, there are no fingerprints. No fingerprints off of Kirby's door to his truck. If somebody's going into that truck, even though it self-locks, anybody going into that truck, they'd have to open the door. No fingerprints on the supposed toolbox outside. Nothing hard as evidence that you would normally see in a criminal case connecting Jeff Spence to this place at that time. that day, that time, nothing. Caitlin, on the other hand, had a lot to protect. She claims that and I find it interesting, see if you can help me out here. Kirby is supposedly killed around 7 p.m. on Wednesday, November the 30th. And somebody does what they do to him. That's not the sort of conduct that you would expect of somebody who would be in a hurry if he has driven all the way from Mississippi to Virginia, Virginia back to Mississippi, and he's going to kill him. He's going to steal all this stuff, and he's going to go to the trouble to get him around by the metal coverall, put him underneath a toolbox. That's not somebody who has driven 2,000 miles, has driven all these hours in a very short period of time. That's somebody more local, somebody who's got time, somebody like Caitlin Spence and whoever she might have as a friend to help her. She's not in any hurry because she's living there at the time. She's not she's not in a hurry to leave. Whoever kills Kirby at 7 o'clock, at 7:15, going to steal all this stuff, steal stuff out of the supposed satchel that we've never seen. He's not going to be hanging around. If they were, wouldn't she see him when she gets there a little after 8 from Boone? Yes, of course she would. So the simple facts of how this supposedly is happening does not support Jeff Spence. It more likely supports Caitlin Spence and whoever she had as friends. And she's called some of the names of her friends. I'm not going to call them again. But y'all heard them. Protecting herself and somebody else, and she's sacrificing her father in the process. There is, well, I'm not laying my hand, I don't want to waste time. Kirby Carpenter had a habit, or practice, I'm not sure it was a habit, a practice of, he owes me money, so he writes me a check. And I say, can you cash this? Then I give him the check back, and he cashes it for me. I put the cash in my pocket, and off I go. That check handed back to him that he had written becomes a receipt. It's like a receipt. And that check to David Barnes was dated April the 21st, 2022. It's here somewhere. You'll see it if you go back. All that check proves is this, that at some point after April the 21st, 2022, at some point, Kirby and Jeff did business. And Jeff was there a lot after August, he was there almost all the time. They did business together. And they had done business before then. But as to that check and why it comes into Jeff's possession, it's because inadvertently it was put into a bag or a box where Kirby was delivering stuff to Jeff that Jeff had bought. Some of the stuff that you see over here. That's all. had done business together. You know, we've heard from Caitlin, and we heard from the Christmas Council that the inside of Kirby's house was basically a mess. It was full of papers and clutter. And the fact that we end up with papers and clutter in some of Jeff's possessions in the bank boxes, it's nothing more than inadvertently grabbing something and sticking it because of all of that. That's all it means. Doesn't mean anything else. There is no connection between anything that the government claims that we did that they have proven beyond a reasonable doubt. There is none. And remember, there were plenty of people who wanted to do Kirby. Ray Palmer, David Hancock. Remember the guy who, Adam Gates, chased him down in Boonville, assaulted him in a parking lot with a gun. Memphis biker gang, Nashville diamond guy. All had reason to want Kirby gone. Drug dealing in and of itself is enough to raise your eyebrows. The government tries to they try to lend credibility to Caitlin's supposed waterfall confession, as he calls it. And I just don't. I have a two-layered response to that supposed waterfall happening. The first layer is it never happened because she knew where he was. The second layer is assuming that it did happen. What she said is not nearly as telling as they want it to sound like. It didn't happen. But, you know, I have two daughters, and I can imagine if either one of my daughters was living life with Caitlin's reality, I could end up saying something very similar to her myself. If I had a daughter who was living with a drug dealer, involved in drug dealing, if I had a daughter who was living with a man who had people engaging in high-speed chases, Adam Gates, for example, chasing my significant other down, assaulting him with a gun. I had a daughter who was living with a man who was emotionally abusive, wasn't committed to the relationship, show up when he gets good and ready. If I had a daughter who was married to a man, or living with a man, who had propensity to smack you if you had anything to say, leave marks on you, black eyes, bruises. If I had a daughter who was living that reality, I could very well see myself saying, look, honey, you got your daughter. You got a lot to live for. You're out of a bad situation. You're no longer living with people who are doing what this guy was doing to you, what he was doing to make a living, what he was doing to make money. The exposure, the high-risk conduct. Don't look a gift horse in the mouth. Move on with your life. I can hear myself saying that. Sure as heck. And I think a father that would say that to a daughter would be a good father. It doesn't mean what Kate would mean, but it never happened because Caitlin knew exactly where her father was on November the 30th, 2022. He was at home with Mom. First time they've had together a dinner in their own home in 4 months. Spent the day working, took a nap, cooking hamburgers. You see it. You'll see it right here. This is digital proof. Your cell phone, you know, that little guy follows you around. And he's recording evidence when you don't think it's recording it. It follows you around, recording evidence. And to the extent that Caitlin says, or they want to make out like Caitlin says she can't get in touch with her father on November 30th. Batteries is broken, whatever. This little guy's not to be denied. And I don't, if that were in fact the case, let me tell you what happens. Let's assume that my battery's broken. And you can't call me because my phone's not working. It's not answering. Or let's assume that, like I do every Friday night, I turn the dadgum thing off. It's off. Well, it's off only to an extent. Because if this little guy is not really everything, if you're calling me and my battery's broken, and you leave me a message, and you call me again and leave me a message, those messages don't go into outer space. When this phone is powered back up with a battery, or I turn it back on, you know what happens to those messages? You usually got 100. They come flooding in. They come flooding in. They're not gone. They come flooding in. And if Kate called her daddy on November 30th, and now I want you to believe there's something sinister's going on because I couldn't get in touch with him. If you left a message, it comes through when the phone is batteried up or turned back on. And we don't have any such evidence because it didn't happen. She's just trying to bolster her claim. They're trying to bolster their evidence. They're trying to make stuff better.
You have 4 minutes.
That's all? Thank you. Exhibit 50. Exhibit 50. This is proof of being in Mississippi on November 30th, 2022 at 8 p.m. This is nothing more than foolishness. Foolishness, playfulness, foolishness between a parent and a daughter. That's all it is. There is no assassination, never will be. There is no business that they're in together. This is just foolishness. And don't be misled by it. You've got all the returns, the entry log. One bank box, another bank box. Just bear in mind that those boxes were visited. This one's 2, 4, 6, 8, 9, 10 times in 1 year. This one's 4, and another one's 7. And what they're showing from these pictures were after all of these visits, the stuff was being put in. Those pictures aren't contemporaneous with Kirby's death. The pictures are a year later, over a year later. Search for it, guys. Don't be misled. Sit down and start talking about this case. Remind each other. When you leave here, you should feel good about the decision you made. And if you don't know who Kirby's killer is, and we don't, and if you're not sure, then your vote is not guilty. Because I don't have to prove anything, even though I have to. I don't have to. He doesn't have to. That's not the way the game is played. That's not the way the system works. The government claims they have to prove everything to make them do it. Thank you so much. I'm done.
All right. Ladies and gentlemen, the jury, let's just take a little break. Go out there a good while, make it pretty quick, and the state be ready for its close anyway. All right, court being recessed until about 15 minutes, 10 to 15 minutes. Nailed it down there, didn't you? All right, everybody good on the jury? You may make your final close for the state.
Thank you, Honor. At the break, I was talking to Carson Moore back there. He's a ADA with our office. We were talking about, how many times have we tried a case where alibi was claimed as a defense and never heard from the alibi? And in all my years, since the year 2000, in all of his years, zero. Where's Karen? Where is she? And that's really important too, because I've heard David Hill up here, and there are some things I agree with about Chris McAllister. I don't know where he is. He should be in here. Anyway, Chris McAllister is a good investigator, and what he did is investigate this case. And he followed the leads, and everything that you have before you is because of his hard work. And according to David Hill, he's a straight up guy. And that's what he did. He followed the leads, and that's why you have this evidence here. And we'll get into that. The first thing that I want to disagree with David Hill about is when they want to drag Kirby Carpenter through the mud even greater today, and in this case, than they did when they dragged his dead body and put a curtain over it and then placed a toolbox on it. They drug him through the mud. Guess what? When Enola was born, Jeff Spence and Karen Spence were there for 4 months. In October, you heard testimony that they all went up to Pennsylvania to meet the family up there. Does that sound like a drug dealer, that they would want him to go and meet the family up there? Does that sound like somebody that was abusive? And he said he was a good father. Anyway, be thinking about those things. We'll come back to them. Now, I want to disagree with the fact that he called Jeff Spence a good father. This case is a story as old as time itself. It's about the lust for gold and what somebody will do for that gold. And I submit to you that when that text, you'll take it back there, you'll be able to see it. A year before this happened, when Jeff Spence, they're talking in a group text with Karen, Jeff, and Caitlin, and they say, hey, what am I going to do, about work? I want to start a business. Jeff Spence lights the fuse. He lights the fuse and says, Assassin's Inc. And she says, I don't think I could do that. And he said, you hire the talent. Now, that may be fun and games, but you've got to take that into context of his other daughter, Carolyn, who he said was filled with hate. Do you believe that? Do you believe Carolyn, his other daughter, came up here and took the stand and testified to you motivated by hate? She told you that she lived in fear of her father, Jeff Spence, and what he would do to her family and her husband. That moment in the McDonald's when they met, and she said, I saw an aggressive side of my father that I had never seen before, is important because it corroborates what Caitlin said. And that shift. The lust for gold and what people will do. And I submit to you that, David Hill says he has 2 daughters, I have 3. And there's I don't want to get too philosophical, but, your daughters are a joy in their youth, and they are your companions in your old age. And what have you heard here? You've heard some main character delusion by Jeff Spence that perverted that whole idea and saw his two daughters as opportunities, a scheme. You heard Carolyn talk about him making notes on these shows, schemes, and different opportunities. And David Hill, you talk about discovery. We downloaded Jeff's phone. We gave it to him, all the contents. We had witnesses up here that could testify about all the contents of his phone. If they would have asked him about beehives, you would see photos of beehives and paraphernalia with beehives. You'd see dogs where he raised dogs. You'd see junk, consistent with Carolyn's testimony. She had to move 3 tons of it out of her yard. You would see all that. He could have asked him. You heard Carolyn say that they want you to believe that he had a lifelong interest in silver and gold and coins. If he would have asked him about what was on Jeff Spence's phone that was supported, there'd be nothing. No gold, no silver. You'd see junk cars. You'd see junk. You'd see washers and dryers and old junkers, but no coins, no gold. If he was a lifelong dealer in silver and gold, why not bring receipts? Why not bring the people that he dealt with? You didn't see that. Do you buy it? I don't. I believe all this that you see, all the valuables that are here, that have been kept in the bank vault during the proceeding of this trial because of its worth, has nothing to do with Jeff Spence, who declared bankruptcy, moved in with Carolyn. They bought him a car, gave him a car, tried to get him on his feet. He saw him as an opportunity. Do you believe that she testified out of hate? Or do you believe that she was testifying out of fear? She doesn't want her whereabouts to be known because of Jeff Spence. That text, Assassin's Inc., lit a fuse. And then he wants to talk about the waterfall conversation between Caitlin and Jeff. Well, June 3rd, 2023, S48, Caitlin sends, and this is in and around the time she testified that waterfall conversation took place in April. And this was sent June 3rd. Thank you, Daddy-O, for making it where I can just take care of our Noah. June 3rd of 2023. She has been sleepy, investigating, laughing, snuggling, nursing, lay with mommy, baby since you left. We're on our second nap. Having the ability to allow her to be all those things on her schedule is just so awesome. This is the bookend to when he lit the fuse a year before with Assassin's Inc., hiring the talent. And you know what he said in response to that? I mean, does this sound like, to me, this is an admission. It's not a normal response from a father who David Hill says is a good father, and we'll get into that too. No more important use for my life or anyone's. Isn't that weird? Isn't that strange? It only makes sense in the context of the fact that we know that he drug Kirby Carpenter's dead body through the mud. There's an old lecture by Russell Conwell called Acres of Diamonds. I don't know if any of y'all have ever heard that, but it's about this farmer in Persia that sells his little farm and goes searching the world for treasure. And what he doesn't realize is that his little farm was where all the diamonds were all along now. Why is that relevant here? Because I think it's profoundly, critically important for you to understand that as it relates to him being a good father. His only 2 children came in here and testified against him. Both of them. And that goes back to his main character delusion, and that delusion and his schemes poisoning their families. He did it with Carolyn, and he was doing it again with Caitlin. And he was successful with Caitlin. You know, if he would have realized that his daughters in and of themselves were his crown jewels, we wouldn't be here today. If he had spent all his schemes and efforts and energy into giving them positive examples and advice, we would not be here today. But he didn't. He saw them as opportunities, exploited it, and poisoned it. And today, ladies and gentlemen, you are the antidote. I am neither foolish nor confused about David Barnes. What we had, what you heard from Chris McAllister, was that he believed that they were all in on it together and they were all charged. Jeff, Carolyn, and Karen, all charged together with the murder of Kirby Carpenter, right? Now, there's one thing that we know from the proof, and that is Caitlin could not have pulled the trigger. Could not have pulled the trigger. We had surveillance of her at the Walmart parking lot shortly after she texted Kirby, "When are you going to be home?" And that was at 6:37. And he arrived, and when she came home, his truck was there, no Kirby. And we already know his body was hidden under the curtains and under the toolbox. If you were to ask Chris McAllister or Maddie Jane or Wendy or Casey whether they were all in on it together, they would say yes. And there are 10 or 11 facts that we can point to that would show that. The Assassins Inc. group text, Caitlin identifying when Kirby was going to be home, Caitlin being at Walmart for 45 minutes on camera, her alibi, Jeff's phone radio silence all day long on 11:30. Now, David Hill wants to talk to you about how difficult that would be for a man of his age to make that trip. You know, on 11/29, going back to Saltville, 8-9 hour trip, rest. The next day is November 30th. He could drive back to Ripley, 8-9 hours, be there between 6:37 and 8:15, you know, probably 7:15, that time frame. We know that if you remember on voir dire, I thought it was a peculiar question that was asked of the panel. You know, how many of you are truck drivers? Well, I don't think any of the truck drivers made it on the jury. But I don't think that drive is as difficult as he wants you to believe. And then I think you can add, he made a big deal about us giving this to him on discovery. You know, where's the beef? Where's Karen? Where's the hamburger? You know, there was something really interesting that she said in there. Dad and I are eating hamburgers in a few minutes. He just got up from a good nap. He worked hard today, inside and out. The hound dogs are back on the porch now. And if you remember, he was reading that to you, and he just said, I don't know what that means. Well, Maddie Jane knows what that means, and some of you hunters don't know what that means. That means the hunt is over. The dogs are on the porch.
Objection, Maddie Jane hasn't testified about anything. Matty Jane hasn't testified about anything, and I object to him quoting what Matty Jane said or would have said. It's not in evidence.
Limit to your testimony.
Well, it's an old expression. Some of you may know what it means too. It's an old expression. Group text, well, actually just between Karen and Caitlin, because as you know, looking in the A1 storage, this man's phone wasn't working that day. Faraday bag. Number 6, Caitlin telling cops a list of people that could have ill will toward Kirby. That was significant to Chris McAllister. That's where all that, who could have done it? It took a year before search warrants were issued. Chris McAllister was working this case doggedly during that whole period of time. And there was just nothing there. Nothing led back to any of those people. Complete access to the home. You heard Carolyn's testimony about what Jeff Spence did to their surveillance system in Virginia. He cut the wires, stole the tools, good father. Are you kidding me? They had another camera up there that caught him in the act. Caught him cutting through the fence where they had tried to secure it because they knew he'd come back and trespass and start taking stuff. This was the controller. They had been there for 4 months. This was on the mantle on the TV, if you remember. And Matty Jane, you heard, called Chris McAllister and said this was behind a bunch of boxes, just thrown off into the back boxes. That was the controller to that surveillance system. Hiding Kirby's body, Caitlin not finding it over that period of time, that was significant to Chris McAllister as well. It gives time and distance before you can begin the investigation, first 48, whatever you want to call it. It gave them a head start, gave him the ability to get back to Virginia. And you know what happened when he went back to Virginia? They want to make light of it, but man, that Chill Howie opening of lockbox. I mean, he's got lockboxes all over the place. And on December the 2nd, almost 2 hours before Matty Jane's on the phone with Caitlin saying, "Where is Kirby? Nobody's been able to get in touch with him." 2 hours before that phone call to 911, we'll get into that. Jeff Spence is opening a lockbox, 11:40 Virginia time, 12/2/22. And you know what was in that box? A bunch of cash, a bunch of valuables, and then Kirby's stuff. Now this is important. It was important to Chris McAllister, it's important to me, and it should be important to you, because nobody disputes that Kirby carried that bag around with him everywhere. It had his business that he was doing that day. Wherever he was going, whatever he was doing, it was in that.
Mr. Creekmore is
Come
arguing
talk to me up
facts,
here.
not in evidence.
Talk to me up here. Talk to me up here.
In his bag. There's no legitimate explanation for why this would be in this man's lockbox. No value to him at all, but it is of value to us. And these are receipts. And you can look at the receipt where Kirby would withdraw money from the bank, and it's the same account number as this checking. It's Kirby's. You can compare them. It's open. You can open this and look at it. Also in here, there are some empty bands of cash. Empty. And the irony is not lost on me that it's Kirby's money that actually paid for the defense.
That's highly improper, Judge, and I object to it.
Y'all come in.
I meant no offense to Mr. Hill. I think there was money in that account. It goes back to bands that were from the People's Bank in Ripley. There's no legitimate reason for Jeff Spence to have those empty bands in his lockbox. And I submit to you that you can come to a legitimate conclusion, and that is that the contents of his bag on December the 2nd, Kirby Carpenter's bag, were dumped in that lockbox. Also, and that's robbery. Also, you've heard testimony, and you can come to this conclusion too legitimately, that he carried around a .22 Magnum because of what he was involved in, what he did, and what he protected. And he had on his person .22 Magnum rounds. There was no gun. That is property of Kirby Carpenter that was never found, and I submit to you it's robbery. Whoever killed him, and we know it was Jeff Spence, took that gun and took that bag, and on December the 2nd, when he was opening that bag, he knew that he was going to get a call, and that they were going to come back, and that crime was going to be a continuing crime. And you heard testimony from Chris McAllister that during that period when they came back, that Sunday, when they were back, in his Cadillac, they were putting silver coins in the back of that Cadillac. How about that? How about that? Mattie Jane's son killed, Casey's brother, Wendy's brother killed. And what's on his mind? What's he doing? He's taking bags of silver that he had nothing to do with in acquiring and getting and obtaining and working hard and putting it in the back of his Cadillac. Number 9. Caitlin happening to find Kirby at the moment Mattie Jane was coming over because no one could contact Kirby. They were worried about him, trying to get him. And Caitlin was on the phone, if you remember the testimony about going up to the deer stand and coming back, on the phone with Mattie Jane. She knew something was wrong. I'm coming over. And Caitlin, instead of saying, come over, says, I found it. That was a significant part of the investigation to Chris McAllister. The delayed emotion on the 911 tape was significant to Chris McAllister. Yeah, it records. Y'all keep that in mind when you call 911. It's recording as soon as you dial it. And then the dispatcher answers and she begins to wail. I'm not foolish and I'm not confused about that. The other thing that is in the Saltville branch lockbox are these wheels. These wheels were in that lockbox. They're in evidence. You can look at them. You know, whether they're working together, who lit the fuse. You can see in Jeff's wheel, these were done in December of 2022. You know, and I submit to you that this is a consolidation or consummation of agreement. And I think that would be what Chris McAllister would say. You know, these are the words in Caitlin's will. This life has been a beautiful one. Anoa, you are your mother's savage daughter. Underlined. That was significant to the investigation. And all these 10, 11 things suggest they're acting together. And makes you wonder, you know, where Karen is. Alibi. That was what he told you from the beginning. Opening statements. Where's Karen? But a year after Kirby's death, around a year after Kirby's death, David Barnes gets arrested for stealing almost everything. Well, that's an exaggeration. But he stole a lot, broke into a lot of businesses in multiple counties. Ends up arrested in Union County. And, you know, I can tell you what they didn't find. They didn't find all this. If he had all this, he wouldn't have been breaking into all those businesses. But what he did say was about a conversation that Jeff was there, Caitlin was there, and he gave Chris McAllister enough for an arrest warrant. So the Mississippi boys had enough for an arrest warrant, and the Virginia boys had enough for a search warrant. And that is what led to the check, the receipts, no legitimate reason for him to have. And it led to a gun, 12-gauge shotgun in his house. And you got a picture of it right here. Buckshot. I mean, at what point do the coincidences and the circumstances taken all together make it beyond any doubt? And wrapped up and dirt on it. Not only did they drag him through the mud on November 30th, not only did they drag him through the mud today, it was wrapped, put under the bed. Yeah. And I submit to you, I mean, we've all
You have 2 minutes, Mr. Creekmore.
heard David Barnes testify. He's burned up on drugs. He's got criminal history that's embarrassing and long. Would you find that compelling? Caitlin Spence was given an opportunity. She was given an opportunity to do the right thing. She did it. She took it. She had a conversation with her daddy. You can corroborate that with that text where he says, "Nothing better for my life or anyone's." That is confirmation that that conversation took place. And that brings us here. The judge has said, you know, you have to use your common sense and sound honest judgment. I'm looking at, 500, 600, 700 years of experience collectively among all of you. Together, you'll go back there, you'll find, whoever your foreman is, you'll use that. But I think that's what it means. Your life experiences, dealing with family, understanding, what it took for daughters to come up here and take the stand against their own father. And not only that, talk about a good father. What struck me was that David Hill would ask for the court's indulgence. He would go over there and get advice from Jeff Spence on how he can attack them and attack their testimony. And I submit to you that Kirby Carpenter, is well known. He had a silver and gold shop across from the courthouse. Oftentimes, when we tried a case in Tippah County, I'd go over there while the jury was deliberating, and I'd look at his guitars. I'm a guitar player. He had a set of country gentlemen Gretsch guitars, and he had a passion for these things. And Chris McAllister, he didn't have anything on his radar about him being some great drug dealer. He testified to that.
Wind it up, Mr. Creekmore.
And I submit to you that those 4 months, Karen Spence didn't come up here and tell you that she witnessed any kind of domestic abuse. It was full of joy for the birth of Enola. And he will never be able to, he'll never be able to experience the joy of her being young, nor will he have her companionship in old age. I submit to you that we've given you everything that Chris McAllister and the Virginia boys did, and that's proof enough. The totality of the circumstances, I'm neither foolish, I'm practical. And Caitlin did the right thing. And she had that conversation with her daddy, knowing that he had killed Kirby Carpenter. And she came in here and told you about it. She raised her right hand and submitted herself to cross-examination, and Karen did not. She did not come in here and raise her hand because she knew that it was a lie. It was a lie, and she could not withstand cross-examination or your scrutiny. That's not who the bell tolls for. It tolls for thee. Don't let him get away with murder. Thank you, Judge.
All right, ladies and gentlemen of the jury, we have 3 alternates, and thankfully nobody got sick. Get them back there to you. I hear the lunch bell ringing. We bringing lunch to you today. They've got some lunch ordered for y'all, and y'all just stay there, and begin your deliberations. But if y'all would go on, head back to the jury room, and we'll wait your decision. Okay?
millimeter Luger Hornady.
You guys also, your team, right, searched the defendant's car, is that correct?
Yes.
Did you find a magazine in that car?
Yes, we did look at a magazine in that car.
You could look at that exhibit. I apologize, I did not name which exhibit that was. Okay. I'm going to hand you what's previously marked as Exhibit 36. You can take one out if you need to.
9mm Luger Hornady.
Okay. So, the live rounds that you found those in Brandon Isbell's car,
Yes.
are they or are they not the same as the shell casings found at the scene?
Yes, they are the same.
Are they or are they not the same as the shell casings found in victim Danielle's Hoyle's car?
Yes,
And you indicated you were looking for the truth, right?
that's correct.
And how do you determine if what he's telling you is the truth?
We're corroborated with the evidence.
All this we've been talking about the last few minutes, does that corroborate everything he told you in that interview room?
Yes.
Now, you also asked, that we had Special Agent Garner up here, and you asked him to look into the telephones look into Brandon Isbell's telephone, correct?
That's correct.
So we got the GPS coordinates.
Yes.
You also got some text messages from his phone, is that correct?
Yes.
And were they at the night of the night of the murder?
Mm-hmm. Yes.
And who was he texting mostly during the night of the murders?
He was texting with Artesia.
Okay. I'm going to pass forward what has previously been marked as exhibit, I believe that's 118. Are those the text messages that were retrieved from Brandon Isbell's phone?
Yes.
You also already indicated that you had GPS coordinates as well, correct?
Yes.
Okay. So I'm going to go ahead and get you, if you could, to read the defendant's text, and I'll read the text from, I guess it's Ms. Stewart. And we're starting, I'm not going to read all of them, but we're starting on page 1 through 47.
All right, we want to point out, you can see at the bottom of the screen, we have a verdict clock up just about 6 minutes in that case, the defendant Jeffrey Spence. So we'll have to see, we'll monitor that if there's a jury question, or of course, if there's a verdict in that case, we will bring that to you. But meantime, why don't we bring in our guest for this hour to talk about the case that we've been watching out of Tennessee. Joining us now from Denver, Colorado, trial attorney Marlo Greer. Marlo, thank you so much for being with us today. Okay, interesting case we've been following out of Tennessee. Most of the focus has been on this interrogation video of the defendant. What are you taking away from the sergeant on the stand?
I'm taking away that he really wants to emphasize that he corroborated everything that the defendant said to bring in his confession. Obviously, they're wanting to fight this confession, say that there was something that was coerced, or that they just looked at the confession and didn't do anything else. So he is focusing on the corroboration. As you noticed during his testimony, he said that many times, that he corroborated it with the evidence. And that's really what I'm getting, is that they really want to focus on, hey, what we did was we verified everything that this defendant said.
Yeah, what are you watching for? How would you approach the cross-examination?
I would approach the cross-examination. For instance, they talked about the fact that he was sleeping. I think that what they're trying to do is gain some sympathy from the jury, even though technically you're not allowed to do that, but you do that all the time. And so I think they're going to focus on how stressful it is to be in a locked room, and that stress and anxiety can cause somebody to fall asleep. I would go through that. I would also go through the fact that there are two detectives coming in and out of the room, and that they left him there for quite some time, and that the overwhelming actions of the police officers are more likely to cause him to say what he said as opposed to it just being a voluntary confession.
All right, Marlo, you're going to be sticking with us all hour long. Coming up, we said it was a busy day. We are going to switch gears yet again and head to the state of Ohio, where coming up next, the Amish mother accused of drowning her 4-year-old son is due back in court for an all-important bond hearing. That's next, right here on Court TV Live.
Tonight, on closing arguments, an Amish mother faces murder charges after allegedly claiming she gave her son to God. We'll dig deeper with the latest from today's hearing.
Closing arguments tonight at 8/7 Central, only on Court TV. Interview with a Killer. New season premieres Saturday, October 25th, only on Court TV.
I threw him in the lake and I gave him to God. And people are going to tell me I am crazy, but he is real.
The chilling moment, 40-year-old Ruth Mueller told officers that she threw her 4-year-old son into a lake, saying she, quote, gave him to God.
Mueller is back in court this hour for a bond hearing after pleading not guilty by reason of insanity for allegedly drowning her son in a local lake last month.
Rescue teams would also later discover the body of her husband in the lake, who Mueller said was swallowed by a fish after not returning from a walk earlier that day.
Ma'am, can you explain to me what happened? Who did you throw in the water?
I gave my son to God.
Your son?
Yes.
Where's your husband?
He went for a walk this morning.
And you haven't seen him
He
since?
didn't ever come back. And we went to the boat and his clothes were there. And God told me he's in the lake and a fish swallowed him. And you're actually supposed to go look for him in the bottom of the lake. And you will find the fish and you will find my husband.
I need to know where your husband's at.
He's at the bottom of the lake in a fish.
He's in a fish.
Yes.
There's no fish large enough on an Atwood to swallow your husband.
He's at the bottom of the lake in a fish.
Mueller has also been charged for allegedly trying to harm her 3 other children during an incident. Let's get you into court now for the start of that hearing.
You may be seated. Thank you. We are now recording in the case entitled The State of Ohio versus Ruth A. Mueller. The case number is 2025 CR 090285. The basis for which we are here today, just taking a step back, we previously had an arraignment in this matter, and at the time of the arraignment, which was back on September the 8th of 2025, at that time, at the time in which we were going to discuss bail, the state of Ohio had made a request that Ms. Mueller be held without bail, as is provided for in Ohio under Revised Code Section 2937.222, which time the court planned to have Ms. Mueller held and schedule a hearing within 3 days. After there was some consultation with counsel, actually September the 29th was the date that was arrived at, which brings us here today. Ruth Mueller is in the courtroom. She is seated at counsel table. She is there with her attorneys in this matter, Ian Friedman and Madeline Grant. The state of Ohio is represented by our county prosecutor, Ryan Steyer. At this hearing today, Ms. Mueller, what's going to happen is, after that request is made by the state, the burden is going to be on the state to try and convince me by what is considered, or what's called, clear and convincing evidence of the following. There essentially are 3 areas that they will be touching upon. One of them is, the question is whether the proof is evident or the presumption great that the accused committed the offense with which the accused is charged. 2, whether the accused poses a substantial risk of serious physical harm to any person or to the community. And whether no release conditions will reasonably assure the safety of that person in the community. At this hearing, and your attorneys are aware of this, they know that they have the opportunity to present evidence as well. Notice goes second, that's all. So shortly I'll have the state begin. My statement, I guess my comments are to the room in general. It's obviously a case that has gathered some attention. It's a case in which, based upon my prior experience, tensions can run high when there are allegations involving a death, particularly when it's a death of a child. For everyone, if there are any outbursts, if there's any disruptions, you'll be asked to leave. This is my warning to you. My advice to you is to let the attorneys do their jobs. But if there are any outbursts, the security knows they'll be asked to leave. There will be no recording, video or audio of these proceedings unless you're with the media. They followed the format of getting permission from me beforehand to do this. If you are not with the media, you cannot record these proceedings. With that, Brian, I'll begin with, do you have any form of an opening statement that you wish to make? Again, you don't have to, I'm just simply offering.
Only, Your Honor, that I think after we present our evidence today, you'll see that this is not a whodunit or what did she do. The proof will certainly be evident in the presumption great that Ruth Mueller admitted to and committed the crime of aggravated murder with regard to her 4-year-old son. That she was a risk that day to herself and others, including her surviving children. And so, again, this will not be a whodunit or what did she do. This will be a case about whether there are any release conditions that can reasonably assure this court of the safety of the community, and particularly not only her children, but herself. And I would suggest that at the culmination of the evidence, there will be no evidence that can provide any reasonable assurance. This isn't a case where an ankle monitor is going to give that court assurance, or that there's any other secured facility other than where she's being held now at this point that can give the court that kind of assurance. And so that's why, Your Honor, we've moved the court as such. We are asking that Ms. Mueller be held without bail, and that we would renew our request that no contact orders be imposed with regard to her surviving children.
Thank you.
Thank you, Your Honor. Your Honor, thank you for hearing our statement, and I appreciate the state's position. I respectfully disagree when we look to the wording of the statute. And I'd like to really break this down as to how we are viewing the statute, Revised Code Section 2937.222. Your Honor just stated the factors that you must consider when making a determination today. And I point to subsection 1, the proof is evident or the presumption great that the accused committed the offense with which the accused is charged. And I think it's easy to just gloss over that, and as our colleague stated a moment ago, just accept that this is not a whodunit case. But to a degree, that I think is just the start of the query. The second part of the query has to be really focused in on the word committed in this case, because I would submit, Your Honor, that if you just look at the common law definition of committed, that by Merriam-Webster, I went right to the basics as to what commit is. It's to carry into action deliberately. There has to be that sort of mental state that goes with the commission of any sort of act. And as we all know, going all the way back to our years of initial formal training as lawyers, we were taught to look at the mens rea and the actus reus. And in this case, I would agree with the prosecutor that the actus reus, the act, in fact, was carried out. We're not here today to dispute who that was, so that's something that I think can be taken by note. The mens rea, however, and that the intention or not.
Okay, we are going to take a break, but listening to defense counsel there make some arguments talking about mens rea. So we'll have to see what the judge decides in this case. I would assume he is not going to let her out, but we'll follow it, let you know. Meantime, that deliberations clock still up for the Jeffrey Spence case that's taking place 24 minutes right now. We'll be right back.
Welcome back to Court TV Live. Matt Johnson alongside Kelly Craft.
Back now to Ohio. We have been watching a bond hearing for a woman whose name is Ruth Mueller.
Mueller has pleaded not guilty by reason of insanity to charges that she drowned her 4-year-old little son in a lake last month.
Let's go back into the courtroom now. We are picking it up right where we left off.
The mens rea, however, and that the intention or knowledge of wrongdoing that constitutes part of the crime, I think is still in question. And without the mens rea, technically, if we look at the statute, subsection 1, one has to question whether or not the definition of committed can be met. The court accepted the plea of not guilty by reason of insanity pursuant to revised code section 2901.01A14 at the last appearance, calling into question whether or not Ms. Mueller could appreciate the wrongfulness of her conduct, and puts into question what her mental state was, whether or not she could form the appropriate mens rea in order to complete the commission of the offense. And so today is going to be spent, Your Honor, talking about what that mental state was at the time. It is our assertion, Your Honor, that that while the act is there, the mental state is not, and therefore the commission cannot be fully determined for purposes of subsection 1. As to the risk of serious physical harm to any person or the community, it needing to be a substantial risk of harm and not just simply based upon what the conduct was, but whether or not there is any pursuant to 3, any release conditions that could reasonably assure the safety of that person in the community. And I believe that the testimony today will have to be that after the incident on August 23rd, when Ms. Mueller was taken into custody and then was confined to a mental health facility, which was a lockdown facility. It was monitored by professionals there with security staff, that there were no concerns for her safety or anyone else's safety. And so I would submit that at the end of the testimony here today, that there would be a combination of release conditions that could ensure Ms. Mueller's safety, the safety of others, until this matter has been completed before Your Honor with final trial in this matter. So with that, I thank the court for the ability to provide opening statement. We are prepared to proceed. We have 4 witnesses, although I know 2 of them will be called by the state. I would just ask that the 2 witnesses not being called by the state, both Sheriff Orvis Campbell and Ranger Lucas Pace, be allowed to be examined subject as if on cross-examination for purposes of the dynamic between the witness and counsel, and also for purposes of expedition.
Okay. Any concern with those requests, Ryan?
Your Honor, I guess the way that this hearing is conducted is really at your discretion. The rules of evidence don't have direct application today. I think it's only fair that if you're going to call a witness, you call them as on direct, unless there's some element of surprise, which I don't think there is in this case.
All right. Ryan, because the rules of evidence don't apply here, I am going to allow them to be treated as if on cross-examination, if nothing else, just to expedite the proceedings. Okay. Before we move in, I did have one last question, and that is, I take your silence from both sides that there are no objections, but on the letter I had written any objection to proceeding today on that outstanding issue.
Not from the state.
Ian, I'd written a letter regarding the question of competency is outstanding in this matter. Any concern with proceeding with this bail hearing today in light of the fact that the evaluation has not been completed yet?
No, I think because this is based solely on the facts of the case that don't really implicate competency issues, so we're fine with it.
Just wanted to be sure. All right, then with that, the state of Ohio may call its first witness.
Okay, I'll call Ranger Rick Anderson.
Mr. Anderson, Make your way up through here. It's a bit of a maze in here today. And you're gonna, there you go. Should I address you as Officer or Ranger Anderson? What do you prefer? Ranger. Okay. Then Ranger Anderson, if you want to have a seat. And please raise your right hand. Ranger Anderson, do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth? If so, please indicate by stating either I swear or I affirm. I affirm. Okay, thank you.
Okay, and can you start by telling us your name?
My name is Richard Anderson.
Okay, and what is your occupation?
I'm a ranger with the Muskingum Watershed Conservancy District.
Okay. And for how long have you been employed in that capacity?
23 years.
Okay. And for how long have you been a certified peace officer in Ohio?
23 years.
Okay. Were you working on August 23rd of this year?
I was.
Okay. And did you have occasion to respond to a call regarding a golf cart that had run into the lake?
I did.
Okay. Do you recall where you were when you received that call?
I was in a nearby cottage area.
Okay. And do you recall about what time that was?
Around, I want to say about 10:30. 10:30. A.M.
So if I were to tell you that the 911 call came in at 10:37 a.m., is that about what time that would have been?
Yes, sir.
Okay. And what information did you have at that point in time before you were dispatched, or as you were dispatched?
I believe I was advised that by Central Dispatch out of Tuscarawas County that a report of a golf cart accident.
Let's go ahead and bring in trial attorney Marlo Greer as this hearing gets underway. Okay, Marlo, so defense counsel is saying that's what he wants to show here, that there are some reasonable accommodations for his client here in order to ensure the safety of her and the community. I don't know, we'll have to see what comes out of this hearing, but I would be doubtful the judge would go along with that idea to release her, but I don't know. What do you think?
I know that we're supposed to be serious here, and I just want to say that it's a very, very serious case, but sometimes lawyers, the only way to have us be able to help through some of these things. Can we just talk about the fact that it's Ranger Rick for just a second? Okay, no, I understand that. Defense has some good points. I think if it were me, I would absolutely stipulate to the fact that she has no contact with her family. I don't know if that's where he's going. He may be going there because he said there were some conditions that would ensure the safety of the community, primarily her other children, and I believe that that would be the no contact. However, she's currently in a lockdown mental health facility, and I think they're going to have a hard time at convincing the judge that that is not where she is supposed to be.
Just talk to me in general with this case, you know, the challenges that the defense may face by putting forward a not guilty by reason of insanity or mental disease or defect. How is that different?
It's different because you need to prove that she really did not understand what she's doing. I think we're going to see a snippet of that as far as this bond hearing, that she really was not able to comprehend what she is doing. And so what she needs is mental health treatment as opposed to a guilty verdict. It also puts your client into a space where, let's say that, and it would not be true in this case, but let's say that there was a possibility of parole. And if she is committed to a mental health institution, in the mental health institution, it continues to say that, no, she still is not able to understand, then she would in fact stay there for life. So it is a risky defense on several different levels. But in this case, it does seem like it is the only viable defense that they do have.
Marlo, thank you. You're going to be sticking with us. Let's take a break right now, a short break, then we'll get you back into Ohio for more of the Amish mother murder case playing out there and this bond hearing with witnesses that are taking the stand. We'll be right back.
Tonight, on closing arguments, an Amish mother faces murder charges after allegedly claiming she gave her son to God. We'll dig deeper with the latest from today's hearing.
Closing arguments tonight at 8/7 Central, only on Court TV.
4 dead students.
None of it seemed to make any sense.
He was evil.
What devastation.
All I could do was scream.
Victim to Verdict with Ted Rowlands. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
Back to Ohio now, where we have been watching a bond hearing for an Amish mom accused of drowning her 4-year-old son.
Ruth Mueller pleaded not guilty by reason of insanity 3 weeks ago. She's facing multiple charges, including murder stemming from the alleged drowning in that lake near her house.
You haven't missed a moment, so let's go back into the courtroom right where we left off.
An accident with possible injury at the Avenue West Marina.
Did you directly respond to that area?
I did.
Okay. And what did you find when you got there?
I entered the parking area of the marina. At that point, I was unable to locate the accident. In a short time, I was directed towards the lake from the parking area. As I approached the lake, I observed another officer talking to Mrs. Miller and her 3 children who were sitting on the bench near the lake.
Okay. And who was that other officer?
Officer Lucas Pace.
Okay. You said you were approached by him?
No, I approached them.
You approached them?
I approached them.
Okay. And what did you observe when you got there?
He was talking to them. Mrs. Miller and her 3 children were sitting on a bench near the lake, and they were wet. Their clothes were wet.
Okay. And did you hear them saying anything?
There was a conversation about occupants on the golf cart. Initially, she began to talk about having a husband and a son, a child in the water. And we had to clarify at that point, were they on the golf cart? And eventually she clarified that they were not on the golf cart, but they were in the lake. So at that point I contacted the Tuscaloosa County Sheriff's Department via telephone, and I advised them what I had and that I needed assistance. Because at that point we believed that they were in the lake someplace. We just didn't know where.
And the lady who was sitting on that bench with her, did you say 3 children?
Yes.
Is she in the courtroom today?
She is.
Okay. Is she the lady sitting here beside Mr. Friedman to the left?
She is.
Okay. What happened next?
As I said, I was talking to the Tuscaloosa County Sheriff's Department on the telephone, and I walked a little bit away from where Officer Pace was speaking with Mrs. Miller, and there was other people around her. I needed a little space so I could hear and I could talk to them. When the conversation ended with the Sheriff's Department, at that point, Mrs. Miller and her children had gotten up from the bench and that they were sitting on, and they began to walk from near the shoreline where they were on the bench towards the buildings at the West Marina, up over a grass area. I was told by Officer Pace that they were going to take us to where the husband and child were. They walked for a short period of time. He told me that he would go get his cruiser because he was going to pick them up in the car and take them to that area, wherever that area was, because we didn't know at that point. So I followed them. Eventually we got beyond the buildings up in the parking lot. On our side of the parking lot, there's a trail system that goes through the park.
So you followed them, you're on foot?
I'm on foot. I'm on foot, and I'm following them, and they're walking along together. And at that point, somewhere in there,
Now, are they just casually walking together?
They're holding hands, and they're walking, and they're talking, perhaps praying, maybe singing. They're a little bit from me, and I can't really tell exactly what they're doing, but they're together.
And your information from Ranger Pace was that they were going to show where you might be looking for these bodies.
Yes.
So where was Ranger Pace?
He was retrieving his vehicle. The idea was that he would get his cruiser, and we'd put him in the cruiser, and that they would go to that location. So I'm following him on foot. I said, they're a little bit ahead of me. They get to a certain point around the parking lot, and they disperse, and they take off running, including Mrs. Miller, onto a trail. This was a very short period of time, and Mrs. Miller went down to her hands and knees. And at that point, I believed I would be able to get to her and get a hold of her so that we didn't do this. She sprang up to her hand, up from her hands and knees.
No, I'm sorry. Is this already after she took off running?
Yes. She took off running, and then it didn't last long. And she went down to her hands and knees. Then she sprang back up to her feet and took off running hard. At that point, she came to a couple on bikes. There's an Amish couple on bikes. She said something to the woman. The woman gave her the bike. She took off on the bike. At that point, I contacted Officer Pace, and I advised him what had happened, and that he could pick me up. He picked me up.
Now, when she took off on the bike, did she take off in a direction opposite you?
The direction in which we were both going when this happened, she continued in that direction. Once Officer Pace picked me up, I got into the vehicle. We drove into the park because we weren't outside the park. We drove into the park. We didn't see her. We located the children in a camp area called B, which is inside. We got the children into the car. They told us that they would take us, lead us to where the boat was docked. So we went there. When we arrived there, we found the bike that Mrs. Miller had been riding, and we looked the boat over, we looked the dock area over. We couldn't find Mrs. Miller, so we got back into the vehicle. We drove back through the park. We got to an area where the trail system picked back up. I told Officer Pace I would get out and walk that area. I found Mrs. Miller face down in very high grass. The grass is approximately chest high along a trail. At that point, I advised her to get up. She was reluctant to get up. I looked towards the trail and I saw the tops of 2 male heads that were on the trail, and I asked them to come over to help me. Well, they came over. When she saw them, she got up. From that point, we walked back to the activity center, which is the park office.
Okay. I want to come back to a lot of that, but I want to play now for you. You indicated that you had called the sheriff's office. Do you remember a Deputy Caden Edwards being the initial responder from the sheriff's office?
Yes, sir.
Okay. And we can have Detective Fisher authenticate this a little better later, but this involves body-worn camera of him where you were involved. And so I want to get to that point here.
Our thanks to our guest for this hour, Marlo Greer. Coming up, don't go anywhere. That body camera footage you've been hearing about Ruth Miller is played in open court. That testimony is coming up next right here on Court TV.
Welcome back to Court TV Live. I'm Kelly Craft, in today for Julia Janae. Thank you so much for joining us this afternoon. And we begin this hour in Ohio, where a bond hearing is underway for the defendant, Ruth Mueller. She is the Amish mother who told officers that she threw her 4-year-old son into a lake, saying she, quote, gave him to God. She has pleaded not guilty by reason of insanity for allegedly drowning her son in a local lake. This was last month. Rescue teams would also later discover the body of Miller's husband in the lake, whom she said was swallowed by a fish after not returning from a walk earlier that day. The defendant has also been charged for allegedly trying to harm her 3 other children during the incident. Let's get you back inside that courtroom now. The court is about to watch some body camera video of Ranger Rick Anderson responding to the scene.
1662. 1662.
There's another one of them right here?
Now that is Deputy Edwards' body cam footage. Is that you walking on the dock?
It is.
Okay. So at what point is that in terms of what you already explained to us?
That would be the, as you saw there earlier, if you could pull that back, you'll see a bike sitting there. Okay, that's the bike that she retrieved from a couple on the trail. When we arrived there, being that we saw the bike, we had hoped to find her there. We did not.
Okay. Now, do you know, is this the dock that is later known to be the dock where the Millers kept their pontoon?
It is.
Okay. Okay. And so you responded there with Ranger Pace?
I did.
In his vehicle?
I did.
Okay. And that's when Deputy Edwards approached you?
Yes.
All right, so can you catch me up on what's going on? We're my dispatch. We're so confused.
Mom evidently drove the golf cart into the lake down at the marina.
Okay.
Sidewalk down by where the rental dock is. Just said God made her, as I've been here to do things.
Yeah, so when I first got here, a bystander was saying that he saw him praying with the kid, saying that it was time for her husband to go and stuff like that. It seems like she's got some.
She said her husband, her youngest son, drowned this morning. So we need to locate her husband and son.
Yeah.
So now the bike that she was on is this bike, and I don't know if you're here or not, but the golf cart, Marina, the husband, we don't know where he's at. The 4-year-old is alleged to have drowned this morning.
And the dad.
Oh, your word. Yeah.
Oh, okay. Okay.
So who is that that's with you at this point, about 10 minutes in?
That's one of the children.
Okay. One of the 2 18-year-old boys?
Yes, sir.
Okay. Do you know where the other 2 were at the time?
In the patrol vehicle.
Okay. And tell us how you found them.
They were going through the campground. They were running through the campground in the area D camp area of Atwood Park.
Okay. Was that shortly before you arrived at the dock here?
It was.
Okay. And you arrive at the dock, you find the bike that she had commandeered, as you explained, and the second 18-year-old boy.
Yes.
I'm being custody and charity right now. You understand that? How old are you? Are you 18? Well, I really like to see custody. That's what I'm charity right now. I'm being custody right now, okay? You understand that?
That's outside. It's not in here.
What do your dad and little brother be out at Area 3? Where's your dad and little brother? In the water? Why do you think they're in the water?
Because that's where they are.
Well, we need to find your mom. Where do you think she might be?
Probably over by the trail somewhere. I'm not sure.
Over by Area 3? You know where Area 3 is?
I do not. I'm not for you guys.
On the outside areas? Yeah, we'll go back out there and check.
Okay. 7940 something.
Okay. Now, I know that's from Officer Edwards' body cam footage, but does that seem accurate as you remember it that day?
It does.
Okay. Can you estimate for how long it had been between when Ruth took off running and you lost her until this moment?
Only an estimate. I would say 30 minutes.
Okay. Now, I'm going to pull up a second clip from Officer Edwards' body cam footage. I'm going to start this one about a minute in. Now that last clip began at about 11:18 a.m. on the clock of the body cam. The 911 call came in about 10:37 a.m. And at this point on the body cam, the clock is at 11:38 a.m. Do you remember, and is that you depicted there with Ruth Mueller and then two other gentlemen?
It is.
Okay. And so do you recognize that scene then?
I do.
Okay. Now, how much time had passed before you found Ruth lying face down in high grass until this event right here?
Once I located her, she got up when the two men beside her came into the grass. She saw them and she got up.
Did she initially respond to your request to get up?
She did not.
Okay.
She did not. When I first located her, she was laying on her stomach with her arms underneath her in the high grass. I told her, I said, get up, Ruth, we need to go. And she did not want to. And when I saw the tops of two male heads on the trail, I asked for help from them. And they came over when she saw them. She stood up and we walked directly to where you see us.
And can that high grass be visualized in this still shot here at 1 minute, 13 seconds into this clip?
It can.
Where is that?
It's just above your cursor there, right in there.
All right. Off to the
Yes,
center right of the photograph.
Yeah, there's a trail system that goes through from the outside areas through there into the park.
Okay. Now, so with the assistance of these two individuals, do you know if these two individuals knew Ruth?
I have no idea.
Okay. And with their assistance, she did get up?
She responded, yes, she got it.
Okay. Was she saying anything to you or otherwise?
She talked about, she advised me that she didn't believe that I was one with God during the walk from the trail back over to where we're at right now. She had issues, she talked about fidelity issues, you know, how I'll phrase that. She advised me that you know, the importance of fidelity, and like I said, she said that I was one with God.
Okay. Did she make any remarks between when you found her and this moment in terms of her
lost husband or son?
She did not.
Okay. And you were present.
We're going to have more of this bond hearing for Ruth Miller in the Amish mother murder case coming up next. Stay with us. You're watching Court TV Live, your front row seat to justice.
Tonight, on closing arguments, an Amish mother faces murder charges after allegedly claiming she gave her son to God. We'll dig deeper with the latest from today's hearing.
Closing arguments tonight at 8/7 Central, only on Court TV.
Covering the country's biggest trials before we bring you inside the courtroom. Plus, the true crime cases you want to know more about in our daily spotlight.
Opening statements with Julie Grant. Mornings at 8/7 Central on Court TV.
will get you back into court in just a moment, but first, we are on a verdict watch in the plotting parents murder trial for Jeffrey Spence. That is taking place out of Mississippi. The jury has been deliberating now for a little bit over an hour. Jeffrey Spence stands accused of fatally shooting his daughter's wealthy boyfriend, Kirby Carpenter. This was back in December of 2022. His defense, though, claims he was not there and that someone else committed the murder. Both sides gave closing arguments earlier today. Take a listen.
Jeff killed Kirby with or without deliberate design. Deliberate design. Now, what is deliberate design? Deliberate design means we don't have to prove that Jeff Spence intended on killing him. He killed him, but we don't have to prove intent. Jeff Spence shot Kirby in the right shoulder and the chest with a shotgun.
They want you to believe, I told you, they concocted this theory that Jeff went from Mississippi to Virginia, came back to Mississippi, did the deed, went back to Virginia, with no proof. There's no proof of any of that. None. Zero. Is that beyond a reasonable doubt?
1 hour and 11 minutes of deliberations in that case so far. We will take you inside of that courtroom once the jury reaches a verdict, or if they do have a question in that case. But now let's head back to Ohio. We are bringing you the bond hearing. This is for defendant Ruth Mueller. A judge will determine whether to let the Amish mother out on bail after she allegedly killed her 4-year-old son at a lake. This was last month. Mueller has pleaded not guilty by reason of insanity. Let's get you back inside that courtroom now. Ranger Rick Anderson is still on direct examination by the state.
You were present initially when you responded, and she was making some remarks along those lines about her. Did you hear those about her?
We asked her, as you can see in the earlier video, about the location of her son and her husband, and what she said there in the video.
Okay. We'll just go ahead and play from here then.
I came to God.
You came to God?
Yes. I lived in the lake and I gave him to God. And people are going to tell me I've been crazy, but he is real. And he loves you. He really does love you. He loves you. And I doubted him. I doubted him so many times. But I have to tell you, he is coming soon. He is coming very soon. Prepare your hearts. The end is close. And I'm for sure supposed to tell you that he does love you. Okay?
Man, can you explain to me what happened? Who did you throw in the water?
I gave my son to God.
Your son?
Yes.
Where's your husband?
He went for a walk this morning.
Do you ever see him
He
since?
never come back. And we went to the boat and his clothes were there. And God told me he in the lake and a fish swallowed him. And you're actually supposed to go look for him in the bottom of the lake. And you will find the fish. And you will find your husband. And then you will believe. But ye of your little faith that did not believe before seeing. So send people down to the bottom of the lake looking for a fish.
How old's your son that's in the lake?
He's sweet. I do.
Okay. 7940 Central. Right with the mother, she's advising that she threw her 4-year-old son in the lake to give him to God. A firm.
They are there.
Now, this is Ranger Pace coming into the picture?
It is.
at the bottom of the lake in a fish.
He's in a fish. There's no fish large enough on an outlet to swallow your husband.
He's at the bottom of the lake in a fish.
Okay. I thought your husband went to the front for a walk.
Yeah, and then we came to the boat, and his clothes were laying in the boat.
Okay.
Tan pants and cream shirt and flip-flops.
Do you have a cell phone?
It's in the camper.
It's in the camper. Where's your camper at?
It's,
Area 3?
I think so. Yeah. It's like a tannish camper.
It's a tannish camper. You don't know what lot number it is? We really need to verify your husband's still with us.
Oh, okay.
Okay.
Well, he's actually just go out in the bottom of the lake.
Well, I can't go to the bottom of the lake. So if we need,
scuba divers.
we're going to have to phone divers in and go to the bottom of the lake.
Please do.
And you're saying
The best ones there are. Because this is a miracle from God. You will see it. You will see it.
you're saying your 4-year-old son's down there too?
He's with God.
Where's his body at? Where did you throw him in the water at?
Off of the dock, all the way.
Where the bike was today? Where the boat was?
Yeah, where the boat was. I know.
When they're supposed to do once a week? I think there was once.
Maybe they have a glass of water.
We can get you water.
Please.
So, we're, right now, we're going to walk up to the squad, okay? That's what we're going to do. We'll put you in the back of the squad.
You will find my husband.
Okay, but you're going to sit down in the back of the squad for us, okay?
Can I actually just sit with my children and have water?
Yeah, we can bring your children over.
Let's go to this one over here. Oh, there we go. We'll bring them.
Now, were you there as she's eventually taken to the squad or the ambulance that was on scene?
Yes.
Okay, and that ambulance was initially called out right after the golf cart went into the water, right?
Yes.
Yeah. Okay. And tell us a little bit about how you and others were able to get her into the ambulance and then to the hospital.
Well, if you play this forward, she'll go over there and she'll sit down on the ground near that tree. And she was there for a short period of time for children. And it was decided that she needed to get into the squad. And as during the time when I came upon her on the trail in the weeds, she wasn't really interested in getting up and going. So we had to pick her up and put her on the gurney because she wouldn't get on herself.
And as I understand it, the investigation was shortly after this handed over to the sheriff's office, is that right?
Yes, sir.
Okay. And other than your initial response, and then, I guess, Ruth and the kids running from you and you finding them and getting her into the squad, did you have any other involvement in this matter?
No.
Okay. Now, you weren't wearing body cam at the time, were you?
No.
Okay. Did you have body cam at the time?
I did not. I had one. It was taken out of service, and I hadn't received the new one.
Okay. I have no further questions.
Okay.
All right, the direct examination of Ranger Rick is completed. Let's bring in trial attorney Marlo Greer. Marlo, all right, thanks for sticking around and continuing to watch this with us. You know, I noticed that Ruth, during this hearing so far, she's been quite emotional. They've been playing that body camera footage, so the direct examination of the Ranger has just finished up. How would you approach Cross? We've heard him say, I mean, this is not a case of who done it.
The cross, I actually don't know that the cross of Ranger Rick is going to be anything related to who done it. I do believe that it's going to re-emphasize that she was talking about giving her child to God and that the end is near, as well as she was indicating that he was not one with God and therefore did not understand what was going on. I believe that that is likely going to be the focus of their insanity defense, and that she did not understand the severity of her actions. In her mind at that time, this was not a murder, but yet it was something that it was very important to her, where in a way she was saving her son from what some were concerned in September was going to be the end of times. So I do believe that they will talk about that because it really does show what her mental state was at that moment.
Marlo, thank you. We're going to squeeze in a quick break. Coming up, the defense cross-examination. The ranger is going to be questioned about Miller's mental state the day he responded to that scene. Stay with us. We're coming right back.
And we'll come
Welcome back to Court TV Live. I'm Kelly Craft, and today, now we're going to head back to Ohio, where we've been watching a bond hearing for a mother accused of drowning her 4-year-old son in a lake. Prosecutors say Mueller threw her son into Atwood Lake, saying she had given her son to the Lord. It happened just hours after Mueller's husband drowned in the same lake while swimming. Mueller has pleaded not guilty by reason of insanity. Let's get you back into that courtroom now. A ranger who responded to the scene has taken the stand, and he is on cross-examination by the defense.
Ranger Anderson, good afternoon. My name is Ian Friedman, and I represent Mrs. Mueller. I've got just a few questions. I don't anticipate it'll take that long. You've described the scope of your investigation. It was limited once Ms. Mueller was in the back of the squad car.
She's put into an ambulance.
Into an ambulance, I apologize. Okay. And so after this matter was turned over to the Tuscarawas County Sheriffs and other law enforcement, you didn't have any other investigatory roles in this? Okay. Thank you. I want to focus with you during this questioning on Mrs. Mueller's mental state during your interactions with her, okay? And my question is, what sort of training and experience do you have with individuals suffering from mental health diseases, mental health ailments?
Only what would be consistent with a police officer in the state of Ohio. I have no special training.
Okay. Have you been involved in a situation before where that rose to the level of what you observed in this case, specifically the mental state that Mrs. Mueller was clearly suffering at the time of your interactions with her?
I've never had another incident like this. As far as her mental capacity, I don't have the training to be able to tell you what the capacity of what position other people were in over the years that we've interacted with. So I really can't answer that.
That's great. Thank you. One of the things that you learned during the course of your interaction that day, your presence that day, was that Mrs. Mueller operated a golf cart, correct?
Yes.
All right. And that golf cart was utilized to, Mrs. Mueller was driving it, went to pick up her daughter, went to pick up the sons. Do you recall that?
Well, that's roughly as I understood it, yes, as I understood it.
Okay. And did you come to understand that Mrs. Mueller had actually crashed that golf cart?
As I understand it, yes.
Okay, and what did you understand about her operation and crashing of that golf cart?
I was advised that she was the driver of the golf cart. The golf cart had gone into the lake near the docks at the West Marina.
Okay. And did it crash into a wall?
No, sir. It went over the rocks and into the water.
Into the water. All right. Now, how long after you first encountered Mrs. Mueller did she tell you what she believed happened, specifically that her son was in the lake?
Well, initially, as we got the call that it was a golf cart accident, and when I arrived there, and I made it to the lake, she was there with her children, and at first, my thought was that perhaps they were on the golf cart with her and her children. But within a few minutes, she stated no, that they weren't on the golf cart. That everybody who was on the golf cart that went into the water with her at that point was accounted for. So at that point, we knew that they were not on the golf cart, but she said they were in the lake.
Okay. And so right away, Mrs. Mueller was letting you know that they, being her son and husband, were in the lake.
Yes.
Okay. And she did not deviate from that during your encounters with her that afternoon of the 23rd, correct?
No.
And she was adamant with you, and I think Ranger Lucas, is it Lucas?
Luke Pace.
I'm sorry?
Luke Pace.
Luke Pace, I'm sorry. With Ranger Pace, she was adamant that a large fish had eaten her husband, correct?
Yes.
Okay. And did she ever deviate from that?
No.
Now, which ranger was it that called out for assistance by the Tuscarora Sheriff's Department?
That would be me.
That would be you. All right. And what was your basis for calling out to them?
The belief that there were people in the lake.
Okay. Now, did you notify anyone that there were issues of any mental health that may be present?
No, I advised dispatch what she was telling us to try to give them a better understanding of the situation. I did not say that I thought there was some type of issue like that. I just advised them what I was hearing, what I was seeing, and what, why I needed him.
Because your goal primarily, obviously at the time, was safety of the child and of the husband. Your mission was to find them.
Yes.
Right. But as you sit here today and you think back upon the situation, as I'm sure you've done many a times, in anticipation of your testimony, did you believe that at the time Mrs. Mueller was suffering from some sort of mental health issue that afternoon?
I didn't know.
Okay. All right, now you talked about on direct that Mrs. Mueller and the children began to walk away from you. And they were holding hands?
As I believe, yes, I recall, yes.
Okay. And they also were praying intently at some point, correct?
Praying, singing, talking, something. They were a distance from me. I couldn't tell exactly. There was some interaction. Something was going on.
And did the children run or just Mrs. Mueller?
Everybody ran.
Everyone ran. And the question that I have for you as it relates to Mrs. Mueller, why did she run away from you at that time?
I don't know.
All right, so there was no questioning of her as to why she ran once she was brought into custody?
No.
Okay. If I were to suggest to you that Mrs. Mueller ran away to, in her mind, meet up with Marcus and Vincent in heaven, you would have no way to know if that was true or not?
No.
Okay. Did she run? Well, you had said you didn't know, so if I were to suggest to you she ran to pray or to go to heaven herself, you'd have no way of knowing one way or the other. Did you identify the two gentlemen that assisted you in taking Mrs. Mueller from the shrubbery?
No.
Do you know if any of your colleagues did? So that as of today, do we know who those two individuals are?
Not that I know.
In your opinion, and again, you don't know exactly what was going on in her head, and I understand that. That would be an excessive expectation. Was Mrs. Mueller acting rationally in your interactions with her?
To say that she was rational, I didn't know Mrs. Miller. I never met Mrs. Miller to the best of my knowledge before this. I meet a lot of people every year working for the Conservancy District. I'm not familiar with how Mrs. Miller normally behaves and the things Mrs. Miller normally says. So I really can't answer that.
Okay, that's fair. But some of the things, I'm not going to get into all of them here at today's hearing, but some of the things that were being discussed about the fish and being reunited with the husband and son, with God and so forth, did that seem out of the ordinary or unusual or something that you could process logically?
Her level of religious devotion, what that means to her, what it means to me, I don't know.
Okay.
She was talking about these things, and I just don't know.
That's fair. That's fair. And then not knowing, would that also hold true if I were to say to you, do you know, or did you formulate an opinion as to whether or not she was sane at the time of the incident? Would the answer be the same, you don't know?
Yeah, I don't.
And last question that I have for you, we had heard on the video a moment ago, the audio as well, Mrs. Miller saying, I gave my son to God. You heard that?
I did.
All right. Do you know if in Ruth's mind she believed that her son was still alive and with God and that she would be reunited with her son?
I don't know what she thought.
Okay. All right. That's all I have. Thank you, Judge. Thank you, Ranger. I appreciate it.
Nothing further.
All right, coming up, we'll hear more about the defendant's mental health when the lead detective takes the stand. That's coming up next. Stay tuned.
On closing arguments, an Amish mother faces murder charges after allegedly claiming she gave her son to God. We'll dig deeper with the latest from today's hearing.
Closing arguments tonight at 8/7 Central, only on Court TV. Interview with a Killer. New season premieres Saturday, October 25th, only on Court TV.
Welcome back. We will get you back to the Amish mother murder trial in Utah in just a moment. But first, an update on a trial of the man accused of assassinating political activist Charlie Kirk. 22-year-old Tyler Robinson was virtually in a Utah courtroom today. This is for a status hearing. He did not appear on camera. He could face the death penalty if convicted of murder in Kirk's death. Prosecutors say they have incriminating text messages sent by Robinson, as well as DNA evidence linking him to the gun that was found at the scene. At today's hearing, both sides brought up concerns over what they called a substantial amount of evidence, and the defense is asking the judge to delay the next preliminary hearing.
It is not our intent to waive a preliminary hearing in this matter. We are going to be seeking that one be set. However, based largely on what the state just referred to as far as the voluminous nature of the discovery materials, we do think it would be prudent to simply reset for another conference, another waiver hearing, a little bit down the road, where we have a better idea once we start seeing the discovery as it rolls in.
The judge did not make any decisions today and set the next status hearing for October 30th. We will continue to follow this case closely and bring you any updates as they become available. But now let's head back to Ohio for a bond hearing for a woman accused of drowning her 4-year-old son. Prosecutors say that Ruth Mueller threw her son into the lake. This was just hours after her husband drowned in the same lake while swimming. Police arrived and they say that she told them she gave the child to the Lord. Mueller is pleading not guilty by reason of insanity. So why don't we get you back inside that courtroom? A new witness is on the stand. This is the lead detective in the case on direct examination by the prosecution.
On August 23rd of this year, we heard testimony that the Rangers were dispatched to a golf cart in the water. And you were here for all that testimony. When did you learn of this situation and how?
So August 23rd was a Saturday. I typically work Monday through Friday with the position that I currently hold at the sheriff's office. So it was a little bit before noon. I want to say 11:50, 11:51-ish. I actually received a call on my cell phone from the sheriff. And he had questioned, hey, do you know what's going on? Have you heard what's going on? Something to that effect. That's not an uncommon call for me to receive on the weekend. It's not uncommon for me to communicate with the sheriff on the weekend. And at that point, I did not know what he was speaking of. So he filled me in just a few of the details that we had a golf cart that had crashed into Atwood Lake, that there was a suggestion of at least 2 missing people. There was potentially some question about some mental health crisis that may have been occurring, and that he thought that some people needed some assistance.
Okay. Do you remember what was said that gave you some concern about this being a mental health crisis?
There was the communication about Ruth suggesting that she had thrown her 4-year-old son into the lake to give him to God. There was also the suggestion that Marcus was at the bottom of the lake in the belly of a fish.
And it's about the time you get the call that she's being transported or about to be transported to Union Hospital, is that right?
Yes, that's correct.
Okay. And so when you get that call, what is your first, what's your next move?
So for purposes of probably too much detail, as soon as I get the call, I had to change clothes because it was a Saturday. I was doing work around the house. So by the time I changed clothes, just a matter of minutes, I had gotten into my patrol vehicle from the sheriff's office and immediately called the sheriff back to let him know that I was on my way, and determined that it was probably in the best interest of the case and for a matter of time's sake for me to respond directly to Union Hospital to meet Ruth there.
Okay. And what was your purpose of doing that?
Honestly, to attempt to gather some information. Do we in fact have 2 missing individuals? Are they in fact in the lake? Or is this a case of an individual who has experienced some type of mental health crisis and is not speaking of anything that is reality currently? And that would obviously, those details would determine our later response.
Okay. Did you respond directly to Union Hospital?
I did.
Tell us about that.
So when I arrived at Union Hospital, they're familiar with me, so they, and to see me on a Saturday was a little concerning to them, I believe. So I walked into the emergency room. I was immediately buzzed back to the treatment rooms there in the emergency room. And there are two specific rooms within Union Hospital in which individuals who have some type of mental health issue, mental health crisis, have been pink slipped, some type of incident that way. They're specifically housed in one of these two rooms. And that's because the rooms themselves can be locked and the contents of the rooms can be controlled so that there's no idea or there's no ability for somebody to grab some kind of equipment and use it then as a weapon. So I made my way towards those two rooms, presuming that that's where we were going to likely end up. Before I even got around the corner, I could hear a female voice singing very loudly. It appeared to be some kind of religious songs, hymns, something to that effect. So Ruth was definitely able to be heard long before I could see her. As soon as I rounded the corner, I did witness Ruth on the ambulance cot. And it was just a few moments then that she was transferred from that cot and placed onto the hospital bed in that room that I was first initially responding to.
Okay. And were you able to engage in a conversation with her?
I was. So upon meeting Ruth for the first time again, it was difficult to make a connection initially because of her loud singing, and she was not really listening to anything else that was going on there. She also had the sheet of the bed covered across her face. And she refused after several requests to remove that sheet from her face, saying that we needed to contact her husband Marcus and that the two of them would share their story together.
Okay. Was she making statements about Marcus and his whereabouts?
She was. She continually would say that Marcus was at the bottom of the lake, that he had been swallowed by a fish, and that's where we would find him.
Okay. Before that, did she make a statement that Marcus would be at their home in Millersburg?
There was a suggestion. I don't recall if it was before that particular statement or after, but there was a statement made that Marcus would be at the home. Ruth also provided a cell phone number for Marcus, suggesting that we should call him and that he would answer, and that he would be able to tell us what had happened and respond to assist her.
Do you know, did anybody attempt to make that phone call to that phone number that she gave?
Yes, there were multiple attempts made. Both dispatch and I personally attempted to make a phone call to that phone number.
Okay.
It went unanswered and to voicemail.
Okay.
Let's go ahead and bring in trial attorney Marlo Greer. Marlo, all right, this is the next witness in this hearing. Before that, we had Ranger Rick that was on the stand, the cross-examination. Getting out from that Ranger that he really has never dealt with a situation like this before. When she was running, maybe she was running to God, running to get her husband, running to pray. What are you taking away from the hearing so far, Marlo?
I really liked the opening questions from the defense attorney as far as what is your experience with mental health issues like this? Have you ever been trained? And I believe Ranger Rick did say he did not have the experience. However, he did come across as, yes, I believe there was something going on here. In other words, what she was saying didn't really make sense from a logical perspective. I also believe having Detective Fisher on the stand now, no offense to Ranger Rick, but Detective Fisher is much more articulate and is presenting in a way that I think the judge will appreciate. It's very succinct. I'm interested to see if the cross-examination is the same. It seems to me that the prosecution is putting on these individuals asking questions about mental health really actually helps the defense here. If the defense argument is to be believed, that you look at the plain language of committed, which includes deliberately, the prosecution is putting on evidence that this may not have been deliberate and she may not have known what she was doing. So I'm curious to see where this goes.
Yeah, I mean, this witness right here is talking about when he arrived on scene and he didn't know if she was being honest as to what was happening, or maybe she was having a breakdown. Who knows? We'll have to see what happens, Marlo. Thank you so much. As always, coming up, more testimony from the lead detective testifying in the bond hearing for Ruth Miller. We'll be back.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott, of course, honored to be with you this Monday, where we are tracking several major trials here at Court TV. First, in Mississippi, a jury has now been deliberating for 1 hour and 55 minutes. The clock is on your screen in the murder trial against Jeffrey Spence, accused of killing his daughter's boyfriend. We will take you there live once they reach a verdict. In Tennessee, testimony continues for Brandon Isabel, the man accused of shooting the mother of his child and throwing their newborn baby in a river. We are streaming that trial live on CourtTV.com and on YouTube. In Florida, it is day 2 in the scattered remains murder trial for Daniel Stearns. The Army veteran is claiming self-defense after allegedly shooting his girlfriend and then burning her remains. Also in Florida, jury selection remains underway in our newest live trial. We are calling it the Deputy Shoots Girlfriend trial. Prosecutors say that Leslie Dale shot his girlfriend in the head, but he claims it was an accident. Opening statements there begin tomorrow. We will keep you updated on all of these trials throughout the day. But for now, let's head back to Ohio and the bond hearing underway for Ruth Mueller. On the stand is lead detective Adam Fisher on direct examination by the state.
And this is while you were at Union Hospital upon your initial response to the situation?
Yes.
Yeah. When she gave that information about Marcus possibly being at the house waiting on her, their home in Millersburg, did you dispatch anyone to verify or falsify that?
I did. So as you can imagine, there's a team of detectives, right? It's not just me, and the others were out and or responding out to assist with this incident. So at the time that some of those comments were made, Detective Cole Morris and Detective Sergeant Ed Jones were requested to go to Millersburg and essentially check the house, see if we could find any activity there, and to gather any other details that we might be able to find.
Okay. And then you've been assigned the lead detective in this investigation, correct?
Yes.
Okay. Did you have a chance to talk with Detectives Jones and Morris about how that went for them?
Yes.
How'd that go?
Yeah, so they, the two of them were able to respond to the Miller residence. While in the area, they also made contact with the bishop, Mervyn Miller, and there was some conversation that was had with the bishop as well as checking the home. There was no activity inside the home. Nobody was located there. Everything appeared to be orderly. Nothing really appeared to be out of place. I say those things because in a number of different incidents that we may investigate, things can be disheveled. Things could be overturned. Things that would suggest that maybe there was some kind of crime there. So those are the things that we would look for. And none of those things were there. Everything appeared to be normal. Speaking with Bishop Miller, I know that he told Sergeant Jones that he believed that Ruth had been experiencing some mental health issues. And he spoke of an incident on the Thursday prior to this. So that would have been August 21st. And in that incident where he and a couple others had an intervention of sorts at Ruth and Marcus's home. He felt that they were misinterpreting passages of the Bible, and they were taking things too far. So they had this intervention. A group of them had come over and had a conversation with Ruth and Marcus about their beliefs.
Okay. Is it fair to say that stemmed from a concern about her mental health?
Yes.
Now, so your initial response was to the hospital. She mentioned that her husband would be at the home waiting for her. You dispatched detectives to go out and look into that. So you're not getting this informational feedback real time at this point. You're still at the hospital, right?
Correct.
Okay. And you're just getting briefings of what happened on the scene as well.
Correct.
Okay. So were you able then to engage with Ruth about what had happened? And if so, what did she tell you?
So yes, some of the conversations with Ruth at this point were a little disjointed. Some of them were like bits and pieces almost, and had to put them back together to make it make sense. And she spoke of Marcus and him being at the bottom of the lake in the belly of a fish. She also spoke of 4-year-old Vincent and how she had thrown Vincent into the lake to give him to God. Ruth said that prior to that incident, at some point, she was asked by God if she was willing to give her husband and children to him, and she had made a promise to him previously about that. So when she and Vincent were on the dock, God spoke to her and told her to throw Vincent into the lake, and she did. She described watching Vincent go under the water and pop back up, and at that moment, God spoke to her, questioning why she was still looking for Vincent after she had given him to God. Ruth said at that point she turned around and walked away.
Okay. That's her account of what happened.
It is.
And that's what she told you at Union Hospital when you responded.
Yes.
Okay. At that point in time, had she mentioned that she was concerned that her husband was missing after having left that morning? Or was that later?
You know, the conversation about being concerned about him missing, I believe, happened in a later conversation. I'm not sure that we had that exact conversation the first time.
But she specifically told you that she threw Vincent off the dock as what she thought was an inspiration from God.
Yes.
What she said.
Yes.
And that she watched him drown.
Essentially, yes.
Okay. What'd you do? What happened next?
During part of my conversation, when I was asking Ruth initially we were communicating about the number for Marcus, Ruth had started to give me a phone number, and then she stopped and she went back, and so I inquired as to what that phone number was, and it was actually a phone number for her father. So I excused myself from her room for a period of time, and I actually spoke with Ruth's father on the phone in an attempt again to gather any kind of information. Did they know the whereabouts of Marcus or Vincent? Have they seen him recently, or them recently? Could her father provide any kind of insight on it? Is this some type of mental crisis or mental snap that has occurred, or are these individuals in fact missing? And during that conversation, Ruth's father was shocked about the phone call, if I can say that, and did not have any idea where Marcus or Vincent may have been. They should have, according to him, been with Ruth and they together at Atwood, and that was the last that he had known.
And then anything else before you left the hospital?
No, I was continuing to try to get as much information as possible, but at that point, I almost feel like the law enforcement and the medical world collided, and they were attempting to treat Ruth for whatever it was that they felt necessary, and they had given her some medications at that point, and she was not able to answer any more questions that I had.
Okay. So what'd you do when you left?
So when I left there, I responded from the hospital directly to Atwood, and I made contact with the units that were there on scene.
And was there some concern about where to look for these bodies?
There was. So there was some suggestion of what is labeled as the Causeway Dock, simply a name that Atwood has given the dock area where the Mueller boat is docked and where this incident had taken place. Or there's another kayak area or a kayak dock closer to the Welcome Center. So as we were going through and talking to some witnesses, there was a witness who had observed Mrs. Miller and her children at the kayak dock, and they were described in what appeared that they were praying. And so that was an area of concern. There was definitely the causeway dock where a lot of these incidents had been described to have taken place, so that was an area of concern as well.
When you arrived back out on scene, were there divers exploring the lake?
There were, yes. And initially they had focused their efforts around the causeway dock or at the causeway dock. If you look or can picture a dock in particular, just kind of going straight out, and the boats are docked on both the left and right side. When I had gotten there, the divers were looking up.
And this, of course, direct examination is from the state. Keep in mind that she is claiming insanity at the time of the crime, so we'll see what the cross-examination looks like. Coming up, we'll have more of the bond hearing for Ruth Mueller in the Amish mother murder case. Stay with us.
My two best friends were just murdered.
Join me for a Court TV true crime series where we take you from the crime scene to the courtroom.
Donna Adelson hates every piece of grass that Dan Marcel ever walked on.
It's something that'll haunt all of us forever.
It always seemed like he was covering or deceiving. This was a whole different level.
Victim to Verdict with Ted Rowlands. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
Welcome back to Court TV Live. We want to go back to Ohio now, where we are bringing you the bond hearing for defendant Ruth Mueller. A judge will determine whether to let the Amish mother out on bail after she allegedly killed her 4-year-old son at a lake last month. Mueller has pleaded not guilty by reason of insanity. Let's get you back inside the courtroom now, where we are hearing from the lead detective. This is Adam Fisher. He is still on direct examination by the state.
When I had gotten there, the divers were looking on both that left and right side. They had moved some boats, and they were looking under where those boats may be.
At some point, did you, I guess, want some clarification from Ruth as to where specifically she would have?
I did. So, obviously, the causeway dock had been explored, the left and the right, under where those boats would be by the divers. We had then moved the divers to the position of the kayak area, or the kayak launch, and they had checked that area, and we were really kind of running out of ideas, so to speak, at this point. We weren't finding anything, which seems to be a good thing, but it's also, you know, there's a lot of suggestion that he may be here, so we needed to make sure that we weren't in fact going to find Vincent and or Marcus. I had made a call at that point in time, so some hours had passed, and I had made a call back to Union Hospital and said, or made the suggestion that I wanted to take Ruth from the hospital, that I wanted to take her with me, I wanted to transport her back to Atwood, and I wanted her to really give us some clarification, like where did these incidents happen, point to me where Vincent went in the water, those kind of things. And as you can imagine, the hospital was not readily agreeable to that, and there was some red tape to get through. So in the meantime, while we were exchanging some phone calls back and forth between me and the hospital, I was notified by one of the Cleveland Clinic police officers that Ruth had drawn a map of where exactly she had placed Vincent in the water.
Did you somehow get an image of that map?
I did. So almost immediately after it was drawn, I received a text message, a picture of the map, and then later I received the actual physical copy of the map that Ruth had drawn.
Okay. And can you just describe what that map depicted?
Sure. So again, if I can take you back to that mental image of the dock, just going straight out, the boats on the left and right side. If we were to just go straight out at the end of the dock, there was a dot, a significant black dot, like it was scribbled in a circle. And that was the indication from Ruth as to where she had thrown Vincent in the water on that particular day.
Okay. I have a question. Are we talking about the causeway dock or are we talking about the kayak?
Sorry, we were talking about the causeway dock. And it was specified there also that it was the causeway dock.
Tell us about the search efforts after that.
With that map in mind and the information that Ruth had drawn this and indicated specifically where she had thrown Vincent into the water, divers were requested to go back to the causeway dock and focus their efforts on in front of, or at the end of that dock, which I later learned that they had not done prior to that request. And when they focused their efforts, it was a very short time when they then located the body of 41 Vincent Mueller about 10 feet off of the end of that dock on the bottom of the lake.
Okay. Do you know approximately what time that would have been?
I want to say roughly around 6:30 p.m.
Okay. About 6:03, I think. Is that any reason to disagree with that?
Nope, it was 6:03 and 0. Stepping backwards.
All right. And then you later that evening went up to the hospital again to interview Ruth, is that right?
I did. So 6:03 p.m., you'd think August 23rd, it stays daylight longer than it does now. So we continued to have the divers search the area. for Marcus. As long as we could, the nighttime hours fell, and we decided it was probably in the best interest of everybody to call off any remaining searches until the next morning. As you could probably imagine, there's still something in my gut, though. We still haven't located somebody else that was talked about at this time, so I felt the need to respond back to Union Hospital and speak with Ruth again to see if I could gather any more information from her regarding Marcus or his location. So after we had called off the search for the evening, I responded back to Union Hospital. Ruth was still in the same room that she had been in previously. She appeared to be much more coherent at this time. I introduced myself to her, requested if she would speak with me, and she agreed. Because of the information that I have now, right? Before it was, do we really have somebody who's missing? Do we have a mental health crisis? Is there something going on? Versus now, we've located a body right where she said she threw him in the lake. I read Ruth her Miranda rights, something that we read people and make sure that they understand what's happening, and she did agree to speak with me at that point, and she walked me right back through this incident again. So we talked about how the day had begun, how the night prior to that had happened. Ruth said that she and the family had arrived at Atwood on Friday. Afternoon, early evening, they had unloaded some stuff from their truck, and the family had gone on the pontoon boat. She said they had a great time. They were cruising around the upper end, something that she described, the upper end of the lake, and the kids were fishing. She said it got dark, but that she and Marcus didn't want to end the fishing trip early or the fun that the kids were having, so they actually didn't get back to the camper until about 10 p.m. that evening. She said she and Marcus went to bed, and the kids stayed up and they watched TV. At about midnight, somewhere around midnight, Ruth said that she and Marcus were awoken by God, that they began to pray and read the Bible, and the two made the decision that they were going to go back to the boat. She said she grabbed a blanket and a Bible, her Bible, and they walked out the door. Now there's the golf cart there that you've heard us talk about before, and she said they were going to drive the golf cart to the boat. However, the neighboring camper, the neighbor was right outside, Chad Engstrom, and she had asked him, I believe actually it was Marcus that had asked, one of them had asked him if Chad would take them to the dock. So there was some discussion as to where the location of the dock was, and then ultimately Chad takes them there. Ruth said that she and Marcus, once they get to the boat, realized that they had forgotten the keys to the boat. So they began to pray again and to experience these different tests of God or from God. They were asked to get into the water, and it's dark. Ruth says that she and Marcus were both nervous about getting in the water initially. But they got in the water. They were to float on their backs at one point, and Marcus began to sink during this, so he swam back to the dock. He was then supposed to be able to pull Ruth from the water onto the dock, and after 3 failed attempts, she had to swim to the back of the boat and climb out using the ladder there. She said that Marcus did not, or let's first say that he started to sink because of his lack of faith, and that he was not able to pull her out of the water because he did not ask God for any strength to do that. There was also a discussion that Marcus was to swim to the sandbar at Atwood Lake, and to give you any kind of direction exactly where a sandbar is, I can't do that. I'm not sure that there is one at Atwood.
All right, let's bring in criminal defense attorney Josh Schiffer. Josh, so much I want to talk to you about, but let's start with this. This is the bond hearing, and the defense is claiming that this woman, Mrs. Ruth Mueller, does not pose a risk to the community, specifically a substantial risk, and therefore she should be released. On the other hand, you have a woman who admitted, she's claiming the insanity defense, but admitted that she threw her 4-year-old into the lake to give her child to God. Your thoughts?
Well, the very discrete question you just presented, which is one of the many factors that the court includes when evaluating someone for bond, is her likelihood to commit additional crimes and threat to the community. And I would think that that's pretty low, considering I don't believe she has access to these children anymore. Certainly none the age of 4. Her other children are late teenagers, going up to a couple of boys at the age of 18, who certainly would be able to protect themselves better from a mother who is acting under some sort of religious fervor or delusion or struggling under a mental health diagnosis. So I don't think that that's the reason to prevent bond as much as there are other considerations. Most specifically, I would be afraid of her own personal safety and well-being. When you have any kind of mental disturbance, that person, there's a lot of volatility involved. And while they can be absolutely fine, that changes quickly, and you can have some really awful results.
And I didn't mean to interrupt you, Josh, but that's exactly what I was going to say, is her risk of hurting herself, even if she's under these beliefs or insane at the time of the next crime, if she were to hurt herself, I think arguing that's a risk to the community. Just briefly, I know we need to take a break, but could that be considered by the court?
Absolutely. The court gets broad discretion, as you know, Judge, in setting the bond, because it's better to have a pound of prevention in so many of these cases, especially with mental health in the middle of it.
Yeah, completely agree with that. The pound of prevention. All right, stand by, Josh. Stay tuned, viewers. We're going to have more of this bond hearing. It is really fascinating as we watch it unfold and learn all of the details behind what happened. This is for Ruth Mueller in Ohio. We'll be back. TV Live, I'm Ashley Wilcott. Happy to be with you today. We want to turn now back to Ohio, where we have been watching a disturbing case. This is a bond hearing for a mother accused of drowning her 4-year-old son in a lake. Prosecutors say that Mueller threw her son into Atwood Lake, saying she had given her son to the Lord. It happened just hours after Miller's husband drowned in the same lake while swimming. Mueller has pleaded not guilty by reason of insanity. Let's get you back inside the courtroom now. The lead detective still on the stand. He is on direct examination. He's recalling his conversations with Mueller at the hospital.
But Marcus was to swim out.
Are we still talking about her account of what happened between midnight and 1 in the morning?
Yes, this is her account still. So they're down and they're doing all of these tests. Marcus was to swim to the sandbar and didn't make it. He gave up in the middle of that and came back to the dock. And then Ruth, was supposed to walk on water. Because of her hesitation and again, her questioning, so to speak, of God when she went to walk on water, she fell right in. She was not able to complete that task. Eventually, they're both out of the water and they're on the dock, and Ruth says that at that point she was wrapped in a blanket and she had asked Marcus just to suffocate her. And when I explored that a little farther, she obviously said that Marcus would not suffocate her and made some suggestion that he had spoke of suffocating her in the past. Again, presumably from some kind of feuds that they may have had in their relationship. When we get to this point, Ruth and Marcus decide that they're going to walk back to the camper. It's just about 5 a.m. according to her account. She says that Marcus had water in his ears and a headache, and she wasn't feeling the best either. And on their walk back to the camper, they had convinced themselves that the things that they were doing were crazy, that this is not reality. And they were laughing and in a good mood by the time they got back. But shortly after getting back to the camper, they changed their thought process and said, no, that was reality. These are the things that we should be doing. And Marcus felt that he had failed God, that he had failed these attempts. And he told Ruth that he was going to go for a walk and then he was going to swim to the sandbar. And he left the camper at this point, roughly about 6, a little after, 5:30, 6 a.m., and Ruth had never seen him again at that point.
That's what Ruth told you?
Yes.
Okay. Backing up just a little bit, you said that Ruth said that she or her husband had asked a neighboring camper to take them from their campsite to the dock.
Yes.
Were you ever able, or was anybody able to corroborate that by talking to that neighboring camper?
Yes, so there was an interview completed with Chad Engstrom, and he confirmed essentially the same story, that he was asked at about midnight, 1 a.m. to take Ruth and her husband to their dock, the Causeway dock. Initially, he said it was a little weird to him that request was made. There was that discussion about where was the dock located, but he didn't necessarily find it a big deal because he was going to some relatives' camper in that area of the Causeway dock, and it was on his way. So he did provide the ride to Ruth and Marcus.
So she says that she and her husband Marcus were out there for some time. They came back, but that Marcus left on foot again to go. She says that he said that he was going to swim to the sandbar.
Yes.
And I believe she said that happened about 5 or 5:30 in the morning.
Yeah, there was a little bit of gray area as to the time that they got back to the camper and then the time that Marcus left. But it was soon after they had gotten to the camper that Marcus then turned around.
Did she say what happened next from her perspective?
So Marcus leaves, and she said that she laid down for a little bit and was awoken about the time that the sun rose.
and Marcus still was not home. So she went out to search for him and pray that his faith remained strong and that he'd be able to complete any of the tasks that were given to him. As she was walking out the door, she said 4-year-old Vincent had asked to go along. So she took him along with her and proceeded to drive to the Causeway Dock. About the time that they were at the Causeway Dock is when she received the communication from God, reminding her of the promise that she had previously made to him, and that she was directed to throw Vincent into the water to give him to God. Ruth said that she proceeded to the end of the dock and she threw Vincent into the water as instructed.
Did she give an account that she was concerned about her husband because she had seen his clothes left on the pontoon at the dock?
She spoke very briefly about his clothes on the pontoon and that they were the same clothes that he had been wearing when he had left the house. So the suggestion that she believed then was he was in the water.
Do you know, did initial responding officers observe clothes on the pontoon boat?
They did. So remember when I spoke of the boats themselves being moved away from that dock for the divers to look under them. When they were moved, there was the discussion that some clothing was on the pontoon.
Okay. Particularly sandals, brown pants, and a tan shirt, I believe.
Yeah, I think it was described by her as when we spoke later about it, tan pants, a cream colored shirt, and sandals. But yes.
Okay. So she gave the account of going out to the dock, or come with Vincent.
Yes.
She said that happened in the golf cart?
They had driven the golf cart to the Causeway Dock, yes.
About throwing Vincent
Still
off.
with us, criminal defense attorney Josh Schiffer. Josh, in Ohio, the definition of not guilty by reason of insanity is that at the time of the commission of the offense, when she threw her son into the lake, that she did not know as a result of a severe mental disease or defect the wrongfulness of her action. Do you think the facts you're hearing right now support that?
It's going to be really hard. And, you know, with the burden on the defendant being so high to prove something that's effervescent, that's hard to determine. You know, you're talking about mental capacity, mental positioning, when there's not a way to really connect that with your average judge or juror. So these are hard anyway. And what I'm hearing doesn't necessarily support what a clear ruling or a clear decision. And as long as that's a little bit muddy, it's tough, because we're talking about a 4-year-old. We're talking about someone in a very conservative community that's extraordinarily familiar with the religious practices of the various Amish communities. That's a tough analysis for a judge, let alone someone presenting a case to a jury. Religious practices vary in nature, especially in these very defined communities. And what looks totally irresponsible or wrong or counterintuitive to us on the outside could be considered very differently in these small communities. It's your community that matters when you're talking about a jury.
And when there's severe mental disease or defect, I also want to hear about her mental health. Has she had any previous treatment for her mental health, any medications, any diagnoses? Maybe we'll hear that during more of the bond hearing. So stay tuned. We're going to take a break. When we come back, we'll continue with the bond hearing for Ruth Mueller. Up next.
Tonight, on closing arguments, an Amish mother faces murder charges after allegedly claiming she gave her son to God. We'll dig deeper with the latest from today's hearing.
Closing arguments tonight at 8/7 Central, only on Court TV.
4 dead students.
None of it seemed to make any sense.
He was evil.
What devastation.
All I can do is scream.
Victim to Verdict with Ted Rowlands. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
We are in Ohio this afternoon for a bond hearing for a woman accused of drowning her 4-year-old son. Prosecutors say that Ruth Mueller threw her son into the lake just hours after her husband drowned in the same lake while he was swimming. When the police arrived, they say she told them that she gave the child to the Lord. Mueller is pleading not guilty by reason of insanity. Let's go back inside that courtroom together now. The lead detective in the case, he's still on the stand on direct examination by the state.
About throwing Vincent off the dock.
Yes.
Watching him drown. What does she say happened next?
Immediately after throwing Vincent into the water, watching him pop back up, Receiving that question from God, turning around and walking away, she proceeded back to the campsite and retrieved 15-year-old Amber. She had driven Amber back to that same dock, the Causeway dock, and had told Amber that she needed to give herself to God and she needed to run off the end of that dock and jump in the lake, to which Amber did. Immediately after Amber had entered the water, she turned around and went back to the campsite again and retrieved both her 18-year-old sons, Jordan and Joel, bringing them to the Causeway dock and instructing them to do the same, give themselves to God and jump off the end of the dock into the lake. And they did.
And they all swam to safety, right?
Yes. At some point, Ruth also jumped off the end of the dock to give herself to God. And then the family came back together on the dock, where they proceeded to put their hands in the water and pray over Marcus and Vincent prior to getting back on the golf cart and leaving the area and heading towards the marina. Ruth said that as they were on their way back, I believe the initial thought was to go back to the campsite. However, Ruth tells me that she missed the road to the campsite and they proceeded traveling down the main roadway there, which ultimately will eventually lead to the marina. And after missing the road to the campsite, she was instructed by God, or she heard that direction from God again, to continue towards the lighthouse. For those that are familiar or not familiar with Atwood, there's the marina, and then there's the Lighthouse Bistro with an actual replica of a lighthouse there. So that was the area that she was going to. Right as she's entering the area of the lighthouse, the marina in that area, she says that she again heard a statement from God that said something to the effect of, "Don't get off the pedal." And so she proceeded to have her foot on the gas pedal of the golf cart, drive down into the lake with her 3 remaining children on the golf cart with her.
Okay. Now, I think in the body cam footage, Deputy Edwards had made some comment about a husband and wife on a bicycle, and I think they were later interviewed as well.
They were. I believe their last name is Ryman. So Mr. and Mrs. Ryman were in the area of the marina, the Lighthouse Bistro, and they actually witnessed Ruth Mueller with the golf cart and her remaining 3 children. And I believe their term that they said was careening out of control. Their initial thought was that something had happened mechanically to the golf cart, that the brakes were out, or that there was some kind of failure that Ruth was not able to control the golf cart. However, soon realized that it was very intentional. So they witnessed her drive through the lighthouse and the marina and down through the grass and over the wall into the water.
Did they in fact say that as they're riding their bikes through the campground at that point in time, that they first saw the family praying near the kayak dock?
They did. So this was the same people that had seen the Miller family praying at the kayak dock, the kayak launch, I believe is what it's called.
Okay. And from there, as they're on their bike ride, they see the golf cart with all 4 of them in it race by them?
Yes.
And then they saw it careen into the lake?
Correct.
Okay. Now, in terms of Marcus Miller's last known whereabouts, we know what Ruth's account was. Was there any witness that was able to corroborate any of that in terms of him being at the dock early in the morning?
There was. So again, in the business that I'm in, we obviously want to know stories or make sure that things make sense. And Ruth said that she had last seen Marcus roughly around the 5:30 mark when he was leaving the camper, and that she had never seen him again, but then later admits that she purposely threw Vincent into the lake. So there was some question as to what happened to Marcus and where is he. We were able to make contact with another individual, Marcus Raver, who describes that he saw an Amish individual around the Causeway dock around 6:30 in the morning of August 23rd. And he remembered specifically that it was 6:30 because there was a sailboat that was docked in that area, and he had taken a picture on his cell phone of the sailboat, and the timestamp of that picture was 6:30. What initially had grabbed his attention is that he knows Marcus's brother, Robert, and he thought that it was initially Robert that was out there, and he was going to go speak to him. And as the two got closer, he soon figured out that it was not Robert, and he did not know Marcus, but was able to describe him in the exact same clothing that was located on the pontoon boat.
Now, the surviving children, 15-year-old daughter and 2 18-year-old twin boys.
Yes.
I think other officers spoke to them at the scene. And then they were later interviewed at the Child Advocacy Center.
Yes.
Last week.
Yes.
Were you there for that?
I was.
Okay. Tell us about those interviews.
Jordan and Joel, 18, males, and I think much like a male demeanor, so to speak, they were very reserved in their interviews or their conversation that we had with them. They both described that they worked for the family company and they liked hunting and fishing. When asked specifically about the details of the events surrounding the August 23rd incident, Joel would not say anything, provided no details. Please excuse me if I have been confused. I'm a twin myself. You think I should know that, but.
All right, still with us, criminal defense attorney Josh Schiffer. Josh, I want to talk about these victims, the 3 teenage children that belonged to Ruth Mueller that were there, that were present, that didn't say much. One was visibly distraught as they were trying to interview her. How do these children as victims come into play in a trial like this and even at a bond hearing?
They're going to be some of the most dispositive and important witnesses because they're the ones that can provide the real window into this family, a family that now doesn't have a father. He unfortunately passed away during this incident and was found at the bottom of the lake, although it does appear his death was almost voluntary, with him entering the water willingly, involving some, according to the tapes, this religious testing. So these kids are really going to be the investigators' best window into the existence in this family and how this claimed mental illness manifested, whether this was an extreme event or whether this was stock for every day. And that's what makes this case so particularly terrifying, is when we get to considering other folks' religious fervor, practices, beliefs, there's not a clear line. There's not a manual saying this is okay, this isn't, this is rational, and this is not rational. Because it's religion. It's one of the most touchy subjects out there, and questioning religious beliefs and practices is a dangerous game when you've got the public weighing in on something with the gravity of a death and the murder of a 4-year-old. But those kids, I expect to hear a lot from them.
And it's just hard for anyone to imagine that religion is a reason for the insanity defense, right? Because you think certainly nobody can just choose to throw their child in, but this is what happened in this case. Just quickly, the insanity defense, it only means at the time of the incident, not necessarily now, correct? In the last 15 seconds.
Absolutely. It's at the time of the crime. Before and after is relevant and admissible, but the culpability is at that moment.
Yeah, absolutely. Now, Josh, you're sticking by. Thank you for that. Coming up next, Michael Ayala is joining me for more of the bond hearing for Ruth Mueller. Wait till you hear what some of these kids told law enforcement. We'll be right back here on Court TV.
in Bombas. Because with every purchase, one is donated. Bombas. Visit bombas.com and get 20% off your first order.
I threw him in the lake and I gave him to God. And people are going to tell me I am crazy, but he is real.
Welcome back to Court TV Live. I'm Ashley Wilcott.
And I'm Michael Ayala. We're both here today giving you your front row seat to justice, and we are in Ohio, where a bond hearing is underway for defendant Ruth Mueller, the Amish mother who told officers, and you just saw it, she threw her 4-year-old son in a lake, saying she, quote, gave him to God.
She has pleaded not guilty by reason of insanity for allegedly drowning her son in a local lake last month.
Rescue teams would also later discover the body of Miller's husband in the lake, who she said was swallowed by a fish after not returning from a walk earlier that day.
The defendant has also been charged for allegedly trying to harm her other 3 children during the incident.
All right, let's get back inside that courtroom now for more testimony from the lead detective in the case, and he is now on direct examination by the prosecution.
I'm confused. I'm a twin myself. You think I should know that, but Joel would not provide any details, simply just remaining silent. He spoke of seeing his mom one time after that incident, and that he thought that she was fine during that incident. Jordan, much the same. Again, not describing a whole lot of detail about the incident, except suggesting that he thought that maybe his mom had at some point seen a doctor for something and could potentially be taking some type of medication. When asked what he would tell her if he got to see her again, he again would not provide any details. He said something to the effect of, I'm not sure what I would tell her. Neither of those boys suggested that anybody had told them to say anything specific in their interviews, alluding to that they had a conversation with their uncle who simply just said, be careful what you say. Amber was visibly emotional and distraught through the interview. She spoke of, when we got to the point of asking about the Atwood incident, she spoke of the incident, and when she talked about Mom leaving with Vincent, she broke down crying and repeatedly saying, she didn't mean to do it. She didn't mean to do it. She didn't mean to do it. She then went on to speak of Mom struggling at times with being mentally stable, that Mom would have her good days and her bad days. That on her bad days, she was described to be not sleep very well and to be sad. She talked of Mom praying, and it was in talking of God, and it was different this time, the moments before leaving with Vincent. And she said that she believed that because Dad hadn't returned from his swim, that Mom was frantic. She described her as frantic, that she was upset and she was frantic, and that she left the camper. She said something else that caught her odd was initially Vincent had asked to go with Mom to look for Dad, and Mom told him no, which is something that Mom doesn't often do with Vincent. But then after a very short time, she said yes to go with her. And so she left with Vincent, returning a short time later and telling her, come with me, come quick, come now. And Amber went with Bruce. And during that travel, their travel to the dock, Amber said that Ruth told her that she had thrown Vincent in the water. And again, at this point in the interview, Amber broke down again, saying she didn't mean to do it. She's a good mom. She didn't mean to do it.
It's fair to say that Amber wasn't nearly as guarded as the boys?
Yes.
Okay. And is what Amber said from her perspective corroborative of Ruth's account of what happened?
Yes.
Did you get the sense that any of these three children were traumatized by the circumstances in their life?
Yes. And I think that was extremely evident by the interviews of the children at Noah's Home. First by Joel just simply shutting down and not answering any more questions when the word Atwood was even mentioned. And then Amber's response, her emotional response throughout the entire incident.
Was it clear that they all still love their mom?
Yes.
Are you familiar with, so I think Ruth was taken medically to Union Hospital given the circumstances.
Yes.
I think she was at Union Hospital for a couple days, and I think that the hospital pink slipped her to another hospital.
Yes, they did.
Okay. Where she was for another several days. Before she was brought back to our county on an arrest warrant.
Correct.
Okay. Since she's been in our county jail, can you tell us how things have gone for Ruth Mueller?
Sure. There have been no complaints from staff or inmates about Ruth. She has been, I guess you could describe her as the model inmate. She doesn't complain. She is not the subject of any formal discipline. She was initially segregated or separated from the entire population of the jail. We first do that based on that mental health history, based on a few of the criteria when she comes in. There was also, obviously she's going to be housed in general population. She's going to be housed with other females, and presumably other females could potentially have children. That could result in some heated emotion or escalated emotion and some potential for violence. So that was just kind of being laid out. At her own request, Ruth was eventually transferred to the female pod, or the general population of the female pod, when there was space. So that recently happened probably about 2 weeks ago. And since that time, there, again, have been no complaints.
Okay. And no reported mental health crises on her behalf?
Breaking news, Mississippi versus Jeffrey Spence. We have that verdict clock up. It's been stopped because we understand the jury is going to be coming back into the courtroom. This is the plotting parents murder trial. Let's go in and see what the judge has to say.
The jury that said jury is not able to come to a unanimous decision. It's signed by one of the jurors, dated 9/29. He said 2005, but he doing his best anyway. He was 20 years off, and 2:55 p.m. I intend to bring the jury back in. I'm not going to let them off. I'm not letting them off this early. I will. If do y'all wish for me to ask the jury what their numerical divide is? I'm going to tell you now, whatever it is, whether it be 6-6 or 11-1, I'm going to send them back for more. But if y'all want me to ask them what the numerical divide is, I will. But either way, we've got too much time and energy invested in this case to stop the deliberations this quickly anyway. Do y'all wish for me to? I intend to. Does anybody have any problem with me giving the sharpening instruction at this time?
Can I see it again? I haven't had the deal with this.
That's the instruction that's normally given when they claim to be hung up. That's Mr. Creekmore, I'll repeat what you. The jury has sent out a note saying that they are unable to reach a unanimous verdict. I'm going to bring them back in. I was asking if whether the parties wish for me to ask them what their numerical divide is, but whatever it is, it's going to be my intention to send them back for more, whether it's 6-6 or 11-1. 5 to 7 or whatever. There's just too much effort been put into this case to let them off this quickly. I will, it's my intention to give them the sharpening instruction. I keep one of those in my back pocket anyway.
Is that what you always give?
I always give. What's that? Yes, he needs to be here anyway. I didn't realize he was here. Thank you.
It's the same one you always give.
All right, so just under 3 hours, this jury comes back saying that they cannot reach a verdict. You heard the judge there. We don't know the number yet. And then I didn't hear a response from the attorneys as to whether they wanted the jury polled or not. We'll have to see how that plays out. But at the end of the day, he said he will give them the sharpened instruction no matter the divide, sending them back in to continue to deliberate.
Which is the right thing. You always have to do that. I just have to mention, if I were an attorney, I'd absolutely want to know the divide. Would you?
This early? I don't know if I would want it this early.
Interesting. All right, let's get back inside the courtroom. There's more action there.
All right, ladies and gentlemen of the jury, I've received your note that said that y'all were unable to reach a unanimous decision. I've got a question for you, but let me preface with this. Don't tell me how many votes you have for guilty and how many votes you have for not guilty. It doesn't matter which way it is. Can you give me a number of how you divide it? Just a number without any direction. Or do you know? You closest one, Mickey, go and tell me. What's your numeric divide? Is it percentage? Yeah, but be careful. Don't tell me if it's so many for guilty and so many for not guilty. Just tell me what the raw numbers is. 6 to 6, 7 to 5, 10 to 2, 11 to 1. Have you got a number? 6 to 6. 6 to 6. That's about that even as you can get. I know I've asked a lot of you. Y'all got things y'all want to do and places you want to be. But there's been a whole lot of work put into this case. And I'm not going to let you go yet. I ask you to go back and continue deliberations and trying to resolve this case. If you can't, you can't. But I want y'all to take a little more time to do it anyway. We just got a lot invested in it. Go ahead and I'm going to give you a little while longer to deliberate, okay? I'll ask you to continue deliberations.
All right, Michael, 6 to 6, that's the information I would want. And I have to tell you, it's the right thing to send them back to keep deliberating, but 6 to 6, I'm not sure they're going to reach a verdict.
Yeah, it's tough. This is one of those cases where I think you and I talked about it. It really could go either way, depending on what you put the most weight on. The credibility of the witnesses, obviously his daughter, one of the more important witnesses for the state, saying that he basically confessed to her. So that's enough to convict right there, but obviously 6 people not buying her testimony.
But I didn't think it was a really great confession. It's her interpretation of, I think he was saying he did it.
Yeah, I would have to agree. All right, let's check in with our guest. Still with us, criminal defense attorney Josh Schiffer. Josh, your reaction to this? I can clearly say 3 hours. It sounds to me, maybe it's a little heated in there, but 3 hours doesn't seem quite enough to sort of throw your hands up and say, hey, we can't come to a decision.
Yeah, it doesn't seem to be a full and fulsome consideration. Shoot, we've seen cases where the juries barely organized themselves within the first couple hours. So to come back after just 3 hours and say, we're deadlocked, there's nothing that's going to happen, I don't see any judge really appreciating that. I did think it's interesting that the judge did poll without carefully, without showing what direction they were leaning, the numerical count, because that's a really dangerous moment there. It can unfairly lean on one side or another. But now that we know it's a 6-6 even split after 3 hours, what it really makes me think is, are these parties going to go back to the table real quick, resize their case, and maybe make a last-minute agreement?
Oh, interesting. I would think it would be hard to reach an agreement. But Josh, one of the things in the prosecution's closing statement, he started it by saying, you have to look at all of this together. You have to look at these other 2 co-defendants. You have to look at the testimony of the daughter. You have to look at all of them together to see that he is guilty of this crime. And I think that's a little bit of the downfall of the state's case here. Is it's a whole lot of having to believe lots of little pieces, not just a circumstantial case, but in my mind, a stretch, I think, to say there was beyond a reasonable doubt that he did it.
Yeah, no, there was definitely some reaching there. It's a big ask. This isn't a case where there's only one clear thing that happened. No, the state's really asking a jury to assemble multiple different facts from a couple of different sources, put them together and assemble a beyond a reasonable doubt argument. And clearly, they've made it with about 50% of the jurors. But that's exactly the kind of argument where I see people that are attached to specific principles really draw a big line in the sand and say, hey, I don't care what it looks like, how it feels. The rules are the rules. And as long as I see this in this way, I can't vote for a conviction, period. Now, that's where the Allen charge really, or their version of the Allen charge, really becomes a bigger leveraging tool.
Let me ask you this real quick as a defense attorney sitting there, and, you know, this could account for the prosecutors as well. When you have 6 to 6 and you send them back, and, you know, a lot of people will say, well, that puts a lot of pressure on a jury to come up with some conclusion. And let's say they do, which means 6 people, one way or the other, would have had to have changed their mind. How do you feel about that as a defense attorney, whether it goes in your favor or not, because that would affect the state versus the defense and vice versa?
Well, changing minds is about what the jury process is, and that's exactly where we hide it, because we've discussed this so many times. If you're arguing or explaining you're losing, how do you change someone's mind? How do you advocate effectively? Those are really hard questions. We put 12 people from the community in a locked room where no one gets to see what happens in order to solve that mushy, ugly problem of how do you get 12 people to either unanimity or a position where they're just going to say, no, we're not going to grant the state's request. This is a great juncture for the parties to sit down and say, you know, work things out.
You know, Michael, you raised a great point, which is that huge toolbox from a truck that's on top of the body. I don't know how one person could alone lift that and manipulate that onto a body.
Yeah, there's a lot about this case that raise a number of questions. My most important issue is if he's traveling back and forth, there should be some evidence of him traveling back and forth, and they never showed that. With all the cameras around the country, you're going from Virginia to Mississippi. I can say, well, here on that day, he's headed back to Mississippi. That would be all I needed to get me over the hump.
But they didn't present that. You're right. All right, stick around. We have to take a break. But coming up next, we're going to head back to Ohio for the bond hearing of Ruth Mueller, the Amish mother accused of drowning her son in a lake. Cross of the lead detective by the defense is up next. Stay with us. We'll be right back.
Tonight, on closing arguments, an Amish mother faces murder charges after allegedly claiming she gave her son to God. We'll dig deeper with the latest from today's hearing.
Closing arguments tonight at 8, 7 Central, only on Court TV. Interview with a Killer. New season premieres Saturday, October 25th, only on Court TV.
Welcome back to Court TV Live. Now let's go back to Ohio, where we are bringing you the bond hearing for defendant Ruth Mueller.
A judge will determine whether to let the Amish mother out on bail after she allegedly killed her 4-year-old son at a lake last month. Mueller has pleaded not guilty by reason of insanity.
Let's go back inside the courtroom now. We are hearing from the lead detective, Adam Fisher, but now the defense has the opportunity for cross-examination.
Detective, good afternoon. We've met, so
yes, sir.
My questions for you, I'm going to ask a few out of order just based upon your direct examination.
Sure.
If at any time that we're conversing through this examination you don't understand something I ask or just need clarification, please just ask me to do so, okay?
Yes, sir.
All right. Now, you had brought up early on when you were talking about your training, you brought up the word crisis in relation to mental health crisis. And what does that mean to you? What do you define as a mental health crisis?
You know, a mental health crisis can be any number of things. There obviously is going to be probably a very specific definition that you might be looking for, but it can be somebody who is overwhelmed in any moment, and their responses or perceived responses occur because of some kind of lack of reality, lack of perception, really just a response to being overwhelmed at any point in time can be any of that.
In your dealings with Mrs. Mueller, how would you describe her reality?
The word that I used earlier, and I think that it really hits home with this, was disheveled. Like her reality at the point was disheveled. Her reality at the point was really based on the foundation of religion and God and the things that he was telling her to do.
The discussion that you were having with her during the first and second interview, was that a kind of a reality different from yours, being in a normal state of mind at that time?
Yes, sir.
Now, one of the issues that you brought up on direct was Mrs. Mueller asking you to make contact with her husband, Marcus, after we know it at this point, and I'd said he had already gone out into the lake and had passed, right?
Correct.
All right. And
I would object to the characterization in that
I'm sorry, maybe I should phrase it.
When he made that statement, we did not know at that point the whereabouts of either Marcus or Vincent.
That's good. I'll withdraw the question. Yeah, sorry. For the post question. So when Mrs. Mueller had asked you to contact Marcus, she suggested that he may be at home. Is that correct?
She did at some point, yes.
Okay. And she had you, or suggested that you call his cell phone as well?
Correct.
All right. And was there anything about that interaction that you deemed to, or chalked up to her just trying to be deceitful to you?
No, not necessarily. You know, at that point, I think the details of all of the incidents were in question. And so it was really just trying to determine what the truth was, not that she was necessarily trying to be deceitful.
Might it have been that what you were being told by Mrs. Mueller, in her reality, she believed what she was saying?
Might have been, sure.
Now, I told you I'm going to skip around just for a moment, and then I'll get into some semblance of order with you. You had heard the testimony before you about Mrs. Mueller trying to run away from the Rangers. Do you recall that?
Yes.
Okay. And did you ever address with her why she ran from the Rangers?
No, because if I'm being honest with you, at the time that I had my first conversation with her, I had not had any contact with any Rangers, nor did I know that she had ran. And the second conversation, again, there was no discussion of that interaction with her having with the Rangers.
Okay. So as you sit here today, you don't know what her purpose in running away from the Rangers was on August 23rd?
Correct.
And just, did Ruth believe on August 23rd, at the time that you went to speak with her, I think she had said to you or it alluded to that the fact that she may see her child and husband again?
Yes.
Okay. And if I were to suggest to you that she believed that her husband and child were still alive when you spoke, you would not have an opinion one way or the other?
Your Honor, I guess I would object to the extent that the questions call for speculation as to the mental state of Ruth Miller or anyone. We only know what she told us in terms of what she believed and was that delusional or not. I mean, that's something that goes to speculation as to mental state, and she's going to be examined. She's in the process of being examined by a forensic psychologist to weigh in on that as it relates to competency and sanity. But in terms of a witness who is not inside her mind at the time, I think it calls for speculation.
Thank you, Eric. So your Section 1 on the bond issue deals with the word commit. And we talked in opening statement as to both the act and the mental state being at play. And I had stated at the time, Your Honor, in introduction of what we intended to do here today, that I would be focused on the mental state because without it, she could not have committed the crime. Hence, that is the reason why the NGRI was put into play. So mental state is an issue when the issue of no bond is raised. It may not be in other instances or if a bond had been set, but here under this statute, when we break down the word commit, mental state does come into play.
All right. I'm going to overrule the objection, maybe for reasons slightly different than what Ian had stated here, but I do believe that the statute does contemplate a consideration of the accused's mental condition, and I'm going to lie.
Thank you, Your Honor. So I'll come back to that question in a minute. And detective, and is that detective or captain detective? How do you?
Wait, whichever you prefer.
Or what do you prefer? You've earned it.
There's a lot there, so I shortened to one. Captain is great.
Captain, very good. So Captain Fisher, you've got 19 years of experience, I believe, before being a detective, or 19 in total?
19 in total.
Okay. All right. And your experience with mental health matters, you seem to indicate you had training beyond that which one would just receive from the academy. Specifically, you've got certification and training in forensic psychology.
Yes.
Okay. What other training do you have as it relates to mental health matters within law enforcement and mental health crises?
Step aside. Here we'll have more of the cross-examination of the lead detective when we return. Keep it here on Court TV.
We'll get you back to court in Ohio in just a moment, but first we have a quick update out of Memphis, Tennessee, where a jury is hearing day 6 of testimony in the Baby in the River murder trial. The defendant, Brandon Isbell, is facing a jury charged with the murders of his newborn daughter and her mother. Right now, the deputy who collected the defendant's clothes in jail is facing cross-examination. Let's take a listen together.
Did you do any bloodshot residue test? You talked about it being a forensic light test, I believe?
Yes. It's not really a test, it's just a search for it.
Okay. And you did that on Mr. Isabel, right?
Yes.
Did you do one that evening or that day on Martisha Stewart?
No.
Did you do any swabs on Miss Stewart?
No.
Did you check her clothing with that forensic light?
I had no interaction with her.
Now, we will bring you updates on that trial later on Court TV, and you can also watch the trial streaming on CourtTV.com and, of course, on our YouTube channel.
And now let's go back to Ohio, where we have been watching a bond hearing for a mother accused of drowning her 4-year-old son in a lake.
Prosecutors say that the defendant threw her son into Atwood Lake, saying that she had given her son to the Lord. It happened just hours after Miller's husband drowned in the same lake while swimming. Miller has pleaded not guilty by reason of insanity.
Let's go back inside the courtroom. The lead detective is still on the stand. He is under cross-examination by the defense.
The crisis intervention team training hostage negotiator. I am one of our only hostage negotiators here in the county. And then just continuous presentations that I give myself, teachings and others that I receive as to any type of mental health issue or crisis within the county.
All right. And do you have experience with matters where pleas of not guilty by reason of insanity or the mental state of a defendant as to whether it constitutes an NGRI? Have you dealt with those sorts of cases before?
Not specifically, no.
Okay. So this case here in the state of Ohio versus Ruth Miller is the first case in which you've been involved with that the issue of whether or not she was not guilty by reason of insanity is central. This will be the first time?
Yeah.
Okay. Now, obviously, prior to August 23rd, 2025, you did not know the family or have any understanding of the Miller family, correct?
That's correct.
And by all accounts, through your investigation, Mrs. Miller was deemed to be a good mom to her 4 children.
Right from their mouths, yes.
Okay. And you received no other evidence that would contradict that?
No.
And just to get this out of the way, and while she's not been charged with it, I just want to make sure that you have determined that Mrs. Miller was not responsible for her husband Marcus Miller's death.
That's correct.
Can you tell me, Captain, please describe your attempts through your investigation or by way of your investigation to understand Ruth Miller's mental health history?
So the mental health history was first brought to us by her own family, suggesting that Ruth had been experiencing some kind of struggles with mental health for approximately the past 6 months. As you're aware, the Amish community addresses mental health and things like that a little differently than us as English. So the documentation or anything like that is generally non-existent. So the family saying that there was some struggles there, the family suggesting that she was seeing a doctor, potentially taking some medication. They could not provide any other information as to who that doctor was or what medication it would be for any further follow-up. And they were described to the Miller family was described to be very private, and that not even their own family would know that information.
And were you able to make any determinations as to how Ruth Miller's mental history played into the incident of August 23rd, 2025?
So the discussions that were had surrounding the previous 6 months of some mental health history were some conversations about misinterpreting of the Bible, some misinterpretation there, some believing that God was coming back very soon to get your affairs in order, and that the family and the bishop and others had had these interventions to talk to Ruth and ultimately Marcus and redirect them on a path that was more appropriate. So I think the conversations about the religious aspects of her mental health issues and then the statements made by her the day of the incident citing that God had told her or directed her to do things really coincides with that. So I think that was the same thing that she had been experiencing.
Okay. And in fact, the family and the bishop were actually very worried about Ruth's mental well-being, and Marcus's for that matter, when they did an intervention just days before being present at Atwood Lake.
Correct.
Yet they felt that perhaps a change of scenery, that going to Atwood Lake might be good for them.
Yes, and that was actually a conversation that Robert had had. Robert is Marcus's brother. Robert had. He was involved in that latest intervention, and described that Marcus was a workaholic, and that's all they ever did was work. So that may be a different, change of scenery, someplace different, a place to relax, to relieve some stress may be helpful.
Okay. So, with your interview of the 3 children, it was described, I believe, by the daughter, perhaps, that her mom was frantic when she came to the campground. Is that right?
Yes.
Okay. And did you seek any clarification on what that meant?
So, not when they came to the campground, but it was the day that Marcus had left in the morning, so on the 23rd, that she had awoken and that she said that her mom appeared frantic. And when there was further discussion about that, she...
Michael, this to me is the important piece when they start talking about other family members suggesting she had mental health issues.
Yeah, not only that, and I'm thinking about it in terms of the trial. This is all great information for the defense.
Right, I know. They get a free look, so to speak, at what is going to be coming. All right, next we'll have more of the bond hearing for Ruth Miller in Ohio. Stay tuned. Court TV, your front row seat to justice.
Tonight, on closing arguments, an Amish mother faces murder charges after allegedly claiming she gave her son to God. We'll dig deeper with the latest from today's hearing.
Closing arguments tonight at 8/7 Central, only on Court TV.
4 dead students.
None of it seemed to make any sense.
He was evil.
What devastation.
All I can do is scream.
Victim to verdict with Ted Rowlands. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
We are in Ohio this afternoon for a bond hearing for a woman accused of drowning her 4-year-old son. Prosecutors say that Ruth Mueller threw her son into the lake just hours after her husband drowned in the same lake while he was swimming. When the police arrived, they say she told them she gave the child to the Lord. Mueller is pleading not guilty by reason of insanity.
All right, let's take you back inside that courtroom now. The lead detective in the case is on cross-examination, testifying about what family members had said about Ruth's mental health.
Clarified that she wasn't sure, but she felt that it was because her mom had not seen her dad and didn't know where she was. The fact that he was quote unquote missing.
And as it related, you had said during direct examination that initially, when Vincent wanted to go with Mrs. Mueller, she said no.
Yes, according to Amber, that was something that had caught her attention, was that Ruth had told him no initially.
And as it relates to time, this would have been moments before Vincent was put in the lake?
Yes.
And so what we know, at least from what was told you, that Ruth was not intending on taking Vincent, at least initially, but only after, do you know how much time passed before she decided to take him?
You know, I don't. The way it would be perceived by me, or the way that it was suggested, was that Vincent had asked to go, Ruth told him no, and then decided to take him back. So whatever we can make that period of time, it did not seem very significant at all.
Okay. Did you ever receive any evidence to suggest that she had asked Vincent to go? That Mrs. Miller had asked Vincent to go to the lake or with her?
No, other than her own testimony saying that she had put him in the golf cart and transported him down there. That was the only other conversation.
Okay. So I want to talk to you for a moment about whether your investigation revealed that Mrs. Miller believed that her child was actually dead when she placed the child in the lake, okay? And so my question to you is this. You spoke to Amber,
yes.
And Amber told you that her mom believed that the child, that being Vincent, would actually come back out of the water if they had enough faith in God.
Correct.
And for all you know, Mrs. Miller truly believed that.
Correct.
Because her reality may have been very different from yours or mine or any of the other first responders that day, not to suggest I was there.
Yes.
I would object, Your Honor. I think we're going down the lines of, for all you know, that's complete speculation. We really need someone who's an expert forensic psychologist to explore those issues. So in terms of the testimony should be limited to what he knows, not for what, for all we know, this could be the case.
I'll ask.
Ryan, I recognize that Adam is not an expert. I'll give you the weight that I believe it deserves. I understand if there were others who may be confused by that. I understand your point, but I recognize he has limits as to what he knows, and I'll give it the weight it deserves.
Very good.
Thank you. Sorry to interrupt you. I thought you would.
Certainly.
Did your investigation also reveal that Ruth believed that her husband, Marcus, would reappear at some point?
Yes.
Okay, tell us about that, please.
In one brief conversation or one brief statement that Ruth had made, she suggested that they were going to the lighthouse. Remember, I spoke with the lighthouse and the marina, that they were going to the lighthouse because she was told by God to go there and she would see Vincent and Marcus again.
Okay, thank you. And it was suggested to you, was it not, by Amber, that her mom was mentally unstable?
Yes.
Okay. And did you seek clarity on what that meant?
Amber used the statement of struggling with mental stability, I think is how she put it. And she just said that Amber noticed that her mom would have good days and bad days, and that on the bad days she would sleep a lot and was very sad. That was, and again at 15, I think that was probably the extent of what she knows.
Sure. And it was described to you by Amber that on that day, August 23rd, that her mom was acting different than normal.
Yes.
Now, did you speak to the Rangers as part of your investigation?
Just in passing, quite honestly. My focus was on Ruth and then locating Vincent and Marcus. And there was a team of detectives that are out there. So, others have spoken and had conversations with them as well. I did not feel that it was necessary at that point for me to.
Now, as the lead detective, you're responsible for this case, correct? All right. And
still with us, criminal defense attorney Josh Schiffer. Josh, let me ask you this. This is a bond hearing, and so the defense said at the beginning of this hearing that there was no substantial risk to the community if she were allowed out. But I think this cross-examination, this testimony, hurts that position because they're saying she had good days, she had bad days, she'd sleep a lot on bad days, she might have been taking meds. All of these things to me say, wait a minute, I think she is a risk to the community.
It's not just that she is a risk or presents a risk. It's how does that relate to the rest of the community and criminal justice at large? Because remember, there are lots of dangerous people wandering around in our communities that are a danger to themselves or others, just not at that exact moment. And the courts are very clear. You're not supposed to be punished by being incarcerated pretrial. It is for specific factors that involve things like likelihood to commit another crime, safety of the community, things like that, because you're supposed to really benefit from your presumption of innocence, and being incarcerated prior to trial is a tremendous hardship that prevents you, really, from exercising your constitutional rights. So the court wants her to be out if it's appropriate. And that's really the admissions that are coming out now, that it's not appropriate sometimes, but it's absolutely appropriate other. And there's not going to be a perfect answer. The judge is going to have to make a tough call about whether even allowing her to have access to the outside world is a betrayal of the obligations he holds to the community.
You know, one of the interesting things about these types of hearings, these preliminary and probable cause hearings, is that there are lax evidence rules. And you heard there an objection by the state regarding some opinions being given by this detective who has no medical training, but the judge allowed him to talk about what his thoughts were regarding the activities of this woman and how he thought she was working mentally. Talk a little bit about those lax rules and how that helps in this process, and it's important to this process.
It's one of the most overlooked, and you're totally knocking this out of the park, Michael, one of the most overlooked tools you can use, because your case has started, your defense has started, the prosecution has started, and those lax rules and kind of less formal procedures, that's how the fishing expeditions catch whoppers. And you really can make huge hay out of the information you gain during these less than prepared initial hearings. You get the opportunity to really take advantage.
Yeah, I mean, Josh, this case, and Michael, there's going to be a lot to come in this case. We have only scratched the little tiny surface of this. All right, Josh Schiffer, thank you so much for all your great expertise today.
Folks, stick around. Coming up, more testimony from the lead detective testifying in the bond hearing for Ruth Mueller. Stay tuned. We'll be right back with more right after this quick break. Welcome back to Court TV Live. I'm Michael Ayala.
And I'm Judge Ashley Wilcott. We will get you back inside the courtroom in just a moment. First, the jury is still deliberating the fate of Jeffrey Spence and the plotting parents' murder trial out of Mississippi. They deliberated for nearly 3 hours before sending a message to the judge saying they were deadlocked. He then told them to continue deliberating. Spence faces life in prison without parole if convicted of killing and robbing his daughter's boyfriend, Kirby Carpenter, back in 2022.
Spence's daughter, Caitlin, who was also his co-defendant, testified against him in exchange for a suspended sentence. Very good deal. The state and the defense focused on her testimony during their closing arguments today.
She comes out flat out and asks Jeff Spence, did you kill Kirby? What did he say? No, I didn't kill him. What are you talking about? The less you know, the better. If you say anything, you'll lose, and no, let me kill me. I did what I had to do. And Caitlin Spence testified that this was a confession.
Making stuff up to protect herself. Caitlin's making stuff up to shift the blame. Caitlin's making stuff up to earn her freedom. She's free. I think you need to bear in mind how much animosity Kirby had going on at the time, how much animosity he has generated over the course of his young life. How many people wanted to do him harm? How many people threatened to shoot him in the face? Not just shoot him in the face.
Now, the jury said they were deadlocked at 6-6, so we'll continue to monitor those deliberations and bring you a verdict if and when it's reached.
Right now, let's go back to Ohio, where a bond hearing is still underway for Ruth Mueller in the Amish mom murder case. A grand jury indicted Mueller on 7 counts, including aggravated murder and domestic violence in connection with the death of her 4-year-old son last month.
Investigators say that Mueller told them that she threw her child into Atwood Lake to, quote, give him to God. She has pleaded not guilty by reason of insanity, and now she wants out of jail.
The hearing is still underway. Let's go back to court. The lead detective, Adam Fisher, is still on the stand, cross-examination by the defense.
Are you familiar with Caden Edwards?
Yes.
Okay, and who is that?
Caden is a deputy with our office.
Okay. And it is true that Caden opined, based upon his involvement in this case, that Mrs. Mueller was, quote, not in her correct state of mind.
Yes.
Okay. Did you talk to Deputy Edwards about his basis for that statement?
Yes. So the conversation that he and I had, Caden is a newer deputy here. So he and I talk frequently as life goes on or as he interacts with people on calls. And so when we spoke about this particular thing, he spoke of my words, Ruth's disjointed statements about the Marcus being in the belly of a fish on the bottom of the lake, and things that to him did not make sense.
Now, I believe, well, if you could answer this for me, who determined that there needed to be a mental health evaluation of Ruth Mueller on that day?
I can't answer that. So I know that collectively, I think that was the push to put Ruth in the back of the squad to have her evaluated. The formal decision for a mental evaluation was done by Cleveland Clinic Union Hospital.
Now, kind of pivoting here for a moment to the golf cart, which you're aware of, the driving the golf cart. Did you look into, or as part of your investigation, that deal with the operation of the golf cart?
Yes.
All right. And do you agree with the descriptions that have been given and throughout your reports and others that Mrs. Mueller operated the golf cart, quote, erratically?
Yes.
At any point, did Mrs. Mueller crash that golf cart to any other part of the grounds other than just going off the dock?
Yes, so there was a conversation and a description that Ruth was observed to be operating the golf cart erratically, that at one point she had even tipped the golf cart over on its side. She had gone back to the camper to retrieve her 18-year-old sons to get them to come back and help her lift the golf cart back up, which they did, and then she proceeded to drive that golf cart.
Did she ever hit any other obstacles that day with the golf cart?
Not that I can recall.
Now, were you involved in the gathering or execution of the search warrant on August 24th?
Yes.
Okay. And can you tell me what your involvement was with the search warrants? And there will be just some specific questions, not so much as to probable cause on a search warrant, but solely as to two pieces of evidence that was examined.
Sure. So the search warrant itself was sought after by me, simply as a matter of procedure. Let's just make sure that there's nothing else in this camper that's going to give us any kind of insight into the case. So the search warrant was obtained. Our process throughout the sheriff's office, for a matter of efficiency, is there were two detectives that were already on scene. So the search warrant was signed, a phone call is made to say the search warrant has been granted, and they entered the camper, proceeded to complete an inventory, take photographs, document the things that were there. While that was happening, I responded to Atwood, and I arrived at the tail end of that execution of the search warrant.
Now, there were different tents, I believe, that were searched. One being tent, and I'd like to refer to tent 1 and tent 3.
So the tents that you're describing are tents with numbers on them. So anytime that we execute a search warrant, if we find something of interest, we will tenant with that number to then photograph it, draw some attention to it, photograph it, and then be able to label it accurately on that inventory that you're likely looking at.
Thank you. And what I'd like to talk to you about is there was a Bible that was found, that was located as part of the search.
Yes.
Okay. And that Bible was not taken, but it was merely photographed, right?
Correct.
Right. I just don't have it yet, or if it has been given over, I apologize, I've not seen it yet. Is there a photograph of the Bible in the open position?
Yes, sir, there is. So
that we are able to determine what may have been viewed last in that Bible?
Yes.
Okay. And do you recall what that was?
I don't.
That's okay. The other thing that I'd like to bring your attention to is tent 3, which were described as over-the-counter supplements. Do you recall that?
Yes.
All right. Those were not taken into evidence either. They were just photographed.
Correct.
Do we know what those supplements were, or why they were being taken?
No, I do not know why they were being taken, what they were. To tell you that off the top of my head, the answer is no. It is documented specifically what those were.
Okay, thank you. Now, during your 2 interviews of Ruth, you would agree with me that the statements that she made to you were unclear at times?
Yes.
Okay. And an example of that lack of clarity would be Ruth telling you that they were in the water, they being presumably a reference to Vincent and her husband, but in heaven, correct?
Yes.
Okay. And prior to that, would you agree with the assertion that Ruth began talking to law enforcement immediately at Atwood Lake when approached?
Yes.
She never tried to deny that the son or husband were in the water, correct?
Correct.
She was clear that she did throw Vincent in the lake, correct?
Yes.
But after that, when being questioned, Ruth spent a lot of time trying to emphasize her reaction to that was that she was emphasizing that God is real.
Yes.
And that she gave her son to God because it was a test from God.
Correct.
Now, what is the word, based upon your training and as it was used in this investigation, what does the word irrational mean to you?
Irrational to me would mean not in a normal, and that's a word response also, but not a normal way of thinking, not a common way of thinking.
And I think that you had stated, or did you state, I should ask, that it was due to her behavior and irrational thought process that Ruth was pink-slipped to the Cleveland Clinic?
Yes.
Okay. And do you know who saw the pig slip at the Cleveland Clinic?
I don't.
Okay. Did you talk to any of the medical staff at the Cleveland Clinic about their treatment or determinations of Ruth Miller?
So my initial response to Cleveland Clinic, I had a very brief discussion with the doctor. I informed him of our response, the fact that there were two missing individuals, a few of the things that Ruth was saying, and I simply made a request to speak with Ruth before they offered her any type of treatment so that I could try to get any information. Specifically asking determinations of medical procedures or treatment is frowned upon in any kind of hospital. There have been search warrants submitted to Cleveland Clinic, so we have those official records. However, the conversations don't generally happen to us specifically.
Thank you. Now, Captain, you had spoken on direct examination about the sheet that was over Mrs. Miller's face at the hospital. It is true that Mrs. Miller kept the sheet on her face and would keep the sheet on her face until she was reconnected with her husband.
Yes, she made that statement.
All right, and she made that statement to you?
Yes.
All right. And the reason that she was going to keep the sheet on her face, or withdraw that question. She stated further to you that at some point they, and that presumed to be Marcus, she and Marcus would tell their story.
Yes.
Okay. Did you ask her to clarify that statement or give any further detail on that statement?
There was a question, to something of the sort of what does that mean, where is he? And she could not provide an answer any different than what she had already provided.
Okay. Now, you had spoken on direct examination about the bishop or family members talking about Mrs. Miller's difficulty sleeping. Do you recall that?
The difficulty sleeping conversation came from Amber, yes.
From Amber, I apologize. So what did you do as part of your investigation to determine whether or not there was any validity to that statement and how it may have affected Ruth Miller's mental state on August 23rd?
I don't know that there was anything else to do at that point with Ruth being in custody at the jail and represented by you. I don't know that it's appropriate to have that conversation with her. So I think just the statement from Amber alone is what it is.
Okay. Did you talk to any of the family?
We need to take a break here. Up next, the lead detective testifies that Miller's actions showed she was delusional.
And the man accused of killing political activist Charlie Kirk during an event at a college campus in Utah has another court hearing. Details of what happened is right after the break. Keep it here on your front row seat to justice.
Tonight, on closing arguments, an Amish mother faces murder charges after allegedly claiming she gave her son to God. We'll dig deeper with the latest from today's hearing.
Closing arguments tonight at 8/7 Central, only on Court TV.
4 dead students.
None of it seemed to make any sense.
He was evil.
What devastation.
All I could do was scream.
Victim to verdict with Ted Rowlands. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
Before we get you back to court, here are a few other cases that Court TV is tracking.
In Utah, the man accused of killing activist Charlie Kirk appeared in court virtually today for a hearing. Tyler Robinson's newly appointed attorney told the judge that the defense does want a preliminary hearing where the judge will determine if there is enough evidence against him to go forward with a trial. Robinson will be back in court for that hearing on October 30th.
In Tennessee, the state has rested in the Baby in the River murder trial. Brandon Isabel is accused of throwing his 2-day-old child into the Mississippi River after he allegedly shot and killed her mother, Danielle Hoyle. Today, the jury saw more text messages between the defendant and his girlfriend at the time of the murders.
And in Florida, jury selection is underway in the deputy shoots girlfriend trial of Leslie Bolio. Now, he faces manslaughter charges after shooting and killing his girlfriend, Paulina Wright, as the two were cleaning guns. He claims her death was accidental. Opening statements are set for tomorrow. Here's Court TV crime and justice correspondent Matt Johnson with more on the case.
Sloppy. That's how a Florida sheriff's deputy described the alcohol-fueled gun training session that ended his girlfriend's life on September 19, 2024. Ocala police were called to his home where they found 25-year-old Paulina Wright dead from a single shot right between the eyes. Investigators say 32-year-old Leslie Bolio, a Marion County deputy, told them it was an accidental discharge. But he also said that he and Wright had 3 margaritas each at dinner before deciding to clean 2 firearms when they returned home. Bolio said that Wright begged him to train her to use the weapons, so he allowed her to dry fire a Glock while pointing it at him. That's when he attempted to dry fire an AR-style pistol rifle at her. He said he'd forgotten that he'd loaded the magazine. Deputy Bolio, who admitted to investigators that the shooting looked really bad, was fired from his job and a month later charged with manslaughter. Paulina Wright's family say that she loved music and comedy shows and was always making people laugh. She'd worked in accounting and bookkeeping and was getting ready to go back to school to be an optometrist tech.
All right, jury selection underway there, and we'll have opening statements for you when they begin. We do need to head back to Ohio now, where testimony continues in the bond hearing for Ruth Miller in the Amish mom murder case.
Talk about what their experience was with Mrs. Miller and whether she was suffering from sleep deprivation.
Yeah.
Now, as it relates to the tests in the water with Marcus, so the tests with Mrs. Miller and Mr. Miller, Marcus, it was communicated to you that any failures to these tests were due to doubts in God.
Yes.
By Mrs. Miller, correct?
Yes.
And I would like to talk about an instance where it was communicated to you, believe that Mrs. Miller tried to actually walk on water.
Yes.
All right, do you remember that?
Yes.
Okay. What was told you and where was that?
It was in the hospital room, and it came directly from Ruth, that she was explaining that one of her tests from God was to walk on water, and that she hesitated. And that her doubt in God, the hesitation, is what caused her the inability to walk on water.
Now, we do know, at least based upon what she said, let me say, no one saw her trying to walk on water, presumably, correct?
Correct.
And you were also told by Mrs. Miller that when she did try to walk on the water, she was actually wearing her clothes, correct?
Correct.
And because she was wearing the clothes, once she went under the water, it was difficult to swim because of the weight of the clothes.
Yes.
Okay. Now, you had brought up the sheriff, Sheriff Orvis Campbell, calling you, I believe on Saturday. It was Saturday, right?
Yes.
Okay. And I'm not getting into necessarily what the job, duties were and so forth. But my question to you is, were you present for his press conference that followed the arrest of Mrs. Miller?
I was.
Okay. And Sheriff Campbell was very involved in this investigation as well, correct?
Yes.
All right. And you and he had communicated back and forth as to findings in this case?
Correct.
And it was described by the sheriff that Ruth Miller, or he opined that there was a detachment from reality. Okay, I'm not asking you as to what he said. Do you recall that being said?
I do.
Okay. Do you agree that the evidence in this case that was gathered pointed to a detachment from reality by Mrs. Miller?
I do.
And Sheriff Campbell had also opined during this very press conference that the investigation pointed to the fact that Mrs. Miller was delusional on August 23rd, 2025. Do you recall that?
I do.
Okay. And do you agree with Sheriff Campbell that Mrs. Miller, or that the investigation evidences that Mrs. Miller was delusional on August 23rd, 2025?
I do.
And Sheriff Campbell had also talked about the fact that what had been conveyed to law enforcement, so I assume you, since you did the interviews, by Mrs. Miller had panned out to be truthful, specifically what was described about Marcus, his actions, what he was wearing, and so forth.
Yes.
And was there anything during your investigation that revealed at any time that Mrs. Miller was being untruthful with you or attempting to deceive you?
No.
Now, there's some other factors that we have to address here today. You obviously did a background check on Mrs. Miller.
Yes.
Right. And that revealed no prior criminal history.
Correct.
We talked earlier on about her being a good mother. There were no reports from anyone, negative reports from anyone related to ill treatment of any of the children prior to August 23rd, 2025.
Correct.
All right, now looking through your records, you, Captain, determined that Ruth Miller was experiencing a mental health crisis as she could not provide clear information, correct?
Correct.
And what was, when you said she was experiencing a mental health crisis, as it relates to Ruth Miller, what were you trying to say in that? What was the mental health crisis that you were referring to in your report?
You know, I think it just goes back to the words that you said. There was a detachment from reality. There was some delusional thinking, which obviously, led to the unfortunate events of that.
Here now to discuss with us criminal defense attorney Laura Yaretsian. Thank you so much for being on with both of us. Some of this testimony really stood out to me, and that is that one of the daughters, the older teenage daughter, said her mom believed that Vincent, the 4-year-old she threw into the lake, would come back from the lake. The mother also believed her husband, who had drowned, would reappear, and the child said that the mother was acting different than usual on that date. Do those facts lend towards the insanity defense?
100%. And you also have the lead detective basically supporting that notion as well. He is testifying that she was detached from reality, that she was delusional, and we also have information that she's never hurt the children before and she's never mistreated them before. She does have mental health issues, but never been violent. Nobody had been concerned about any violence or harm to others. So yes, I mean, I can see a lot of this lending support to an insanity defense and also some support to the defense request that she be released on bond.
Yeah, well, that was going to be my question. Does it actually help with the question of the day, which is the fact that should she be released on bond in this case? And if so, how?
This could be a double-edged sword, right? Because it sounds like someone who's delusional would be a risk, right, to public safety. However, if they can maybe request certain conditions of release to attach to the release, including that she be on her meds, that she see psychiatrists, therapists, maybe be on house arrest, be closely supervised, and as long as she's under prescriptions and she abides by specific rules and conditions, whatever they may be, right, to keep her in a safe environment and to ensure public safety, then yes, she could be released despite some of these issues because we don't have any prior issues from her. We don't have any prior violence or any other indication that she could be violent. She was basically detached from reality, delusional. And we can tell that the argument would be that she didn't really mean to harm her child, but she, especially when she believes that the child would come back. But again, as long as you can keep the person under control, meaning with the right supervision, they can make that argument that it's safe for her to be released and she would be a flight risk.
I think she has to have the right treatment. Just quickly, I did want to ask you, a substantial risk to the community is one of the things they consider today. What about a substantial risk to herself? Is that something that could cause a judge to say, in your opinion, nope, she is staying in jail?
It's probably one of the factors that the court would consider, but of course the priority is always the risk to the community. But I'm sure that the judge will consider that too. But again, the solution is one and the same. As long as she is in the right program or is seeing the right mental health, is in the right mental health facility or at home getting the right treatment, is complying with any medications, prescription medications that she has, sees her psychiatrist, she's her therapist, and does everything that the court is ordering her, then she wouldn't be a risk to herself or to the public. Just because someone has a mental health issue doesn't mean that they're going to be, they're posing a risk. As long as they get the treatment they need, they would be fine.
Yeah, that's always the risk, though. That's always the risk. All right, Laura, stand by. We're going to step aside here for a quick break. When we come back, the lead detective testifies that when the 4-year-old victim was found, the defendant asked him if her son was with God. Keep it here on your front row seat to justice.
Welcome back to Court TV Live. I'm Ashley Wilcott.
And I'm Michael Ayala. We are bringing you testimony in a bond hearing in the Amish mom murder case going on in Ohio. Ruth Miller is charged with aggravated murder and domestic violence in connection with the death of her 4-year-old son last month. But she claims she was insane at the time.
Her attorneys are now fighting to have her released on bond. The lead detective is wrapping up his testimony. Let's go back in.
You're familiar with the term malingering?
Yes.
Okay, and what does that mean to you?
Malingering is something that's like persistent or continuing.
Did you ever perceive any of what Mrs. Miller told you or the way that she was telling you? Did you ever determine that to be suspect or suspicious or an attempt to deceive you? Anything that was not genuine?
No.
Now, you had talked about on direct interview 2, and you had said that Mrs. Miller seemed to be much more coherent during that interview.
On the second one, yes.
Yes. All right. And Mrs. Miller did not change any of her facts from interview 1 to interview 2, but she did add some facts to interview 2, correct?
Correct.
And what Ruth added to you was that she was actually talking to God on August 23rd. So she was actually having a conversation with God.
Correct.
And she had elaborated to you that God, and her words were, as per the report, quote, he wanted us to do something, and that happened before midnight coming into the critical day.
Yes.
And she had told you, Captain, that she had been witness to miracles lately.
Yeah.
Okay. Did you ask her to clarify what that meant and what miracles she may have observed?
You know, I recall having that conversation, but I don't recall what her response was.
Okay. As far as approximation of time, how long before the incident? When I use the word incident, I'm speaking of August 23rd, 2025. Do you know how long it was before that she was witnessing these miracles?
I don't.
And in fact, not only did Mrs. Miller talk about Marcus and the fish, but she also added during the second interview that God had asked her to get swallowed by a fish.
She did.
Okay. And did you have her give you any further detail on that, or were you at this point just noting what she was saying?
So I was noting what she was saying. She did explain in this particular instance that God had asked her to be swallowed by a fish, that she, again, had some hesitation, did not want that to happen, made a statement that if God wanted her to, that she would.
Right. So she actually was willing, as she told you, she was actually willing, if God wanted her to be swallowed by a fish.
Yes.
And there was nothing about that you took as her being trying to be dishonest or just disingenuous in any way?
No.
As far as physically is concerned, well, you can't say necessarily physically. The question that I have for you is, Mrs. Miller had also described to you that her head had hurt and was full of water. Do you remember that?
Yes.
Okay. Can you tell us about that statement, please?
She had made that statement after talking about the test that God was giving she and Marcus on the dock, and after they had been in the water, that's when she had said that after they had removed themselves from the water and were walking back to the camper, that's when her head was full of water and her head hurt.
Now, during direct, you had talked about the child coming back up above the water?
Yes.
Okay. And was there any sort of discussion about Ruth trying to reach out to the child?
So the first conversation, she spoke of looking at him, being questioned by God, turning and walking away. The second conversation, she said that she attempted to reach down for Vincent and could not, so terminated.
All right, we have some news coming out of Mississippi in the plotting parents murder trial of Jeffrey Spence. The clock has stopped, as you notice, at 4 hours and 24 minutes. And our understanding is that the jury has come back after coming back earlier, saying they were deadlocked at 6-6. They've come back again, saying that they are still deadlocked.
I'm not surprised, Michael. So that first time they came back was right before 3 hours. Now they're at almost 4.5 hours. So an hour and a half later, they're still deadlocked. I think when we learn the split, 6-6, and the judge made clear, I don't want to know who's voting for what, came back 6-6. I thought that could be a tough one to get a unanimous jury.
Yeah, I agree. But I also agreed with his point that 3 hours wasn't enough.
Agree.
Right? 3 hours wasn't enough. They spent a lot of time on this trial, wanted them to go back. He gave them what they call in Mississippi a Sharpton instruction, which is to go back and continue to try to work through this and get some sort of conclusion to this trial. But it looks like after another hour and a half, they were unable to do that.
That's right, the Sharpton instruction, just another name for what some call an Allen charge. Sometimes it's the dynamite charge. And I have to tell you, I don't think I've ever seen a trial, Michael, where the jury is told that at least once. They got to go back and keep trying.
Yeah, you know what's interesting? They didn't want to know how the split was. So had it been 11-1, they didn't want to know which way. But 6-6, it's right in the middle.
Yeah.
So it's like you got 6-4, 6 against. You know where they stand. And I think you and I agreed when he sent them back, it was going to be a difficult thing to turn 6 people one way or the other.
Yeah, I completely agree with you. I also think that to your point, you and I have talked about, there is some reasonable doubt here. Like, I do understand why this is a split jury that could definitely do one or the other. As I understand it, Michael, there's nothing happening in that courtroom yet, so it's a perfect time to squeeze in a break so that we can bring you updates from that courtroom just as soon as we know more. Stay here with us on Court TV, your front row seat to justice.
Tonight, on closing arguments, an Amish mother faces murder charges after allegedly claiming she gave her son to God. We'll dig deeper with the latest from today's hearing.
Closing arguments tonight at 8/7 Central, only on Court TV.
4 dead students.
None of it seemed to make any sense.
He was evil.
What devastation.
All I could do was scream.
Victim to verdict with Ted Rowlands. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
All right, folks, we want to take you back now to Mississippi for that breaking news in the plotting parents murder trial. So let's get back into court.
I believe that's all of you. All right, I've received another note from the jury indicating that y'all have still not been able to reach a unanimous decision. I caution you again, don't tell me which side, for lack of better words, winning. But what's the score? Has the score changed any?
No.
Score has not changed any? Do you feel that, and I'm sort of directing this to all of you are, not just Mr. Williams, but do you think that further deliberations, do you think any chance of any further deliberations moving the needle anywhere? Any of y'all do you think further deliberations will be any of use or not? Don't be bashful. Speak out, shake your head, whatever you think anyway. I see some of you shaking your head no. I see a lot of you shaking your head no. All right. Y'all just bear with me one just second. Well, I'm gonna let y'all go. I'm not gonna send you back if the needle hadn't moved any and you don't think there's any chance of it. If it was a 10-2 vote, 11-1, 9-3, even maybe 6-6 is as far as you can get anyway. And I want to say I appreciate y'all's service. We all knew going in this was going to be a tough case. It's going to take some of your time, and it's going to be a difficult case. I appreciate your service. Y'all be free to go. If you need an excuse for work or anything, y'all stop down to Miss Nowicki's office and they'll give you an excuse. If you want to talk to anyone about your jury service, you're free to do so. If you don't want to talk to anyone about your jury service, tell them you don't want to talk about it. I don't have any reason to think they would persist in asking you questions, but if they do, you get in touch with me or one of these court officials, and we will put a stop to it, okay? I don't have any reason to expect anyway to have any repercussions for your jury service whatsoever. But thank you. If you need that work excuse or anything, stop off at Miss Nowicki's office. And y'all go. Thank you for your service. And y'all have a good evening, okay?
All right, Michael, the jury is leaving, declares a mistrial 6-6, nobody moved.
Yeah, and as the judge said, that's as far apart as you can get. Perhaps had there been a different split, he might have made them go further. At first glance, 4.5 hours doesn't seem like a lot, but split 6-6, I think it was the right decision.
And twice, right? He gave him an hour and a half and still split. Let's go back in.
Y'all consult your calendars about when you may want to, if and then you want to retry this case. I got my wagon loaded between now and the first of the year, but sometime after the first of the year, if y'all wish to have a retrial, I'll get with you and get on calendars anyway.
Yeah, the Kip County term is in February, and I believe that Pontotoc has a term at the same time, so they have to do a special session.
We've burned through one Tipper County term by this case. I don't know if we can sacrifice another term. It probably needs to be outside the normal Tipper County term anyway. That's just my thoughts anyway. We've got y'all get together and look at your calendars and see this case I want to get disposed of. I'll move something on my calendar if I need to make time for this case.
Can we schedule a time in the next week or so for the setting?
I'll be in Lafayette County. I'll be in Lafayette County week after next. No, next. I'll be in Lafayette County starting Monday all week. Mr. Hill will be there. I'm sure somebody at the DA's office will be there. If y'all need me next week, I'll be there all week, okay?
We'll plan to set it.
Okay.
Plan to set it at a future date at that time.
Yeah, we'll see about a future date at that time. At this time, Mr. Spence will remain in custody at this time, and I'll hear any motions y'all might have. We need to have some discussions about the matters that have been introduced in the evidence, specifically the things of value. We'll entertain those thoughts. We can do that off the record after we have excused the jury, but we need to decide how we're going to do those things, okay? All right? Unless there's anything else?
No.
Court be in recess, okay?
All right, so that's that big million-dollar question. Are they going to try him again? Let's bring back in criminal defense attorney Laura Uretzian to discuss. Laura, that's the big question now. At this point, considering how this case went, what do you think about the choice that the prosecution is going to make? If they haven't made it, they're not going to make it today. They have to think about it, but will and should they try him again?
They may, but you know what? The 6-6 is a message to them. Basically, they were only able to convince 6 out of 12. This is the definite win for the defense, and it may give the prosecution an opportunity to maybe resolve this case. Maybe it makes sense to come to some kind of a resolution on this instead of retrying it, because at least I'm sure they've given it their best, and even their best only got in 50% of the jurors.
And you can see here, we are showing, Laura, this is the victim's mother in the middle, gray hair, crying, being consoled inside the courtroom after the judge declared a mistrial. Michael, and regardless of what I think in terms of the legalities of it, you can't take away from the emotion of it, and she lost her son. Let me ask you this, Laura. How do you feel, or how do you think the mother and daughter feel? They just saw this unfold, and they both took deals. They both agreed to 10 years, now suspended, and the daughter's was contingent on her testifying, which she did. Whether or not it was satisfactory to the state now remains a completely different issue. But what do you think they may be thinking at this juncture?
That maybe they should have took this to trial themselves.
I
That's
agree.
what they're thinking, instead of caving. Because sometimes people get scared. It's not necessarily because they're guilty. People get scared because they're facing, a large number. And it could be, 20, 25 years to life, and they would rather have a number that they know at some point is going to end and they can walk out of prison versus taking that risk. And in this case, it looks like the dad gambled the right way. He was the one who was willing to take the risk, and it was to his benefit.
Yeah, it's interesting because at the end of the day, when you see this kind of pain, it makes you realize, the difficulty that the justice system has and what it's being asked to do. But at the end of the day, Laura, this was a case where I thought the evidence was lacking. And I don't think they should bother to bring another case unless they go back and get more evidence. One of the things I was looking for in this case, if you're going to tell me that a man drove to Virginia from Mississippi, then from Virginia back to Mississippi, there's got to be some record of it somewhere, some video. Without something like that, I'm not sure it's worth bringing again. Your thoughts?
Agreed. That is the prosecution theory, right? They drove all of these miles that could have took them 30 to 36 hours. And if there's not one scintilla of evidence of that, that in itself, I'm sure, was problematic to this jury. And I would rethink my strategy, and I would probably either resolve this case or dismiss it.
Yeah. So I do have to mention this. We have learned that the mother of the victim that you saw there in the middle did collapse. An ambulance was called for her. So certainly I can't imagine the pain, and we'll stay tuned. All right, Laura Uretzian, thank you so much for joining us tonight.
All right, folks, stick around. Coming up in our next hour, we're going to take you back to Ohio for more on the bond hearing for Ruth Miller and the Amish mom murder case.
At one point, she said, the devil got to me in the moment. But again, whether God made her do it, whether the devil made her do it, whether she's faking it, or whether she's honestly delusional, for purposes of today, it doesn't matter. What matters is there's nothing that can assure this court that she's not going to have some break again.
All right, as you heard, while the state urges the judge not to grant bond for Ruth Miller, He has suggested a hefty price for her freedom if she does win her motion. Keep it here on Court TV, your front row seat to justice.